Aloha mai kako and good morning. This is the May 13th, 2021 Land Use Commission meeting, which is being held using interactive conference technology, linking video conference participants and other interested individuals of the public via the Zoom internet conferencing program to comply with state and county official operational directives during the COVID-19 pandemic. Members of the public are able to view the meeting via the Zoom webinar platform. For all meeting participants, I would like to stress to everyone the importance of speaking slowly, clearly, directly into your microphone and not interrupting other parties. Please also be aware for all meeting participants that this meeting is being recorded on the digital record of the Zoom meeting. Your continued participation is your implied consent to be part of the public record of the event. If you do not wish to be part of the public record, you should exit the meeting now. This Zoom conferencing technology allows the parties and each participating commissioner individual remote access to the meeting proceedings via our own personal digital devices. Because of that, please also note that due to matters entirely outside of our own control, occasional disruptions to connectivity may occur for one or more members of the meeting at any given time. If such disruptions occur, please let us know, and please be patient as we try to restore audiovisual signals so we can conduct business during the ongoing pandemic. There's one agenda item on today's agenda where public testimony will be allowed regarding legislative updates. If you are calling into the meeting via telephone function rather than via software, and you wish to testify at that time, you would use the key sequence *9 to raise your hand and *6 to ask to be unmuted. I will repeat those directions when the time comes. I will note for everyone at this time that we will attempt to take breaks about 10 minutes every hour. My name is Jonathan Likeke Scheuer. I currently have the pleasure and honor of serving as the Land Use Commission Chair. Along with me, Commissioners Edmund Axon, who despite his Zoom background is on Oahu rather than in Lahaina. Commissioner Don Chang, who despite appearing to be on the summit of either Haleakala or Mauna Kea, is also on the island of Oahu. Gary Okuda, Arnold Wong, our Hawaii Island Commissioner, Nancy Cabral, and our Executive Officer, Daniel Ordenker, our Chief Planner, Scott Derrickson, our Chief Clerk, Riley Hakoda, our Deputy Attorney General, Linda Chow, our Program Specialist, Natasha Canones, and our Court Reporter, Jean McManus, are all on the island of Oahu. Commissioner Leo Higashi is on Maui, and Commissioner Dan Giovanni is holding it up on Kauai. We currently have 8 seated commissioners of a possible 9. I want to address a little bit of scheduling for today. Commissioner Leo Higashi, you have a court appearance that you have to make today?
Yes, I'll be gone from 9:30, I think, or thereabouts until probably 10:15 at the latest.
Okay, so what I would like to ask for, sorry, and also Commissioner Giovanni, you need to leave the meeting at what time today? You're muted. You're muted, Commissioner Giovanni, so I didn't hear your response.
12 noon till approximately 2 p.m., maybe less.
Okay. What I'd like to ask for the commissioners to consider is that for the purposes of the efficiency of our proceedings, I'd like to have somebody consider making a motion that we move our agenda item 8, LUC legislative update, to 9:30, to the point at which Commissioner Ohigashi has to leave, so that we can conduct that business, and then he will be able not have to go back and review any record.
I shall move.
Okay, it's been moved by Commissioner Giovanni. Is there a second?
And
It's been seconded by Commissioner Arnold Wong. Is there any discussion on the motion? Seeing none, Mr. Ordenko, would you roll call the commission?
Thank you, Mr. Chair. You can make a motion.
Done.
Commissioner Giovanni made the motion,
motion is to
Commissioner
adjust the
Wong
agenda.
seconded it.
Is to adjust, is just the agenda. Commissioner Giovanni,
Aye.
Commissioner Wong,
Aye.
Commissioner Axon,
Aye.
Commissioner Cabral,
Yes.
Commissioner Chang,
Aye.
Commissioner Ohigashi,
Aye, if I'm allowed to vote.
Commissioner Okuda,
Yes.
and Chair Wong, Chair Schreier.
Aye.
Thank you, Chair. So the motion passes unanimously.
Okay, thank you.
Mr. Chair, I do have a disclosure that I have reviewed the last, I believe it was approximately 50 minutes of the hearing that I missed yesterday. And I reviewed it on the Zoom.
Thank you, Commissioner
Oh, yeah.
Higashi. Are there other commissioners with similar statements?
Here.
Commissioner Wong, then Commissioner Chang.
Yes, I reviewed the portions that I missed, especially Commissioner Chang's discussion with the witnesses yesterday.
Okay,
It was very informative. Thank you, Commissioner Chang.
Thank you.
Commissioner Chang.
Yes, I too reviewed the recordings of this portion of the meeting that I missed. Thank you very much.
Anyone else? No. Okay. With that, we're on a continued hearing on our agenda item related to docket number A11791 HG Kauai Joint Venture LLC HoKua Place, Kauai, a petition to amend the land use district boundary of certain land situated at Kapa'a, Island of Kauai, State of Hawaii, consisting of 97 acres from the agricultural district to the urban district, tax map key 44-3-003, a portion of lot 1. Will the parties please identify yourselves for the record?
Good morning, Mr. Chairman and Commissioners. William Ewan and Jana Ahu on behalf of Petitioner HG Kauai Joint Venture LLC.
Thank you, Mr. Yuan.
And good morning, Chair, Commissioners, Deputy County Attorney Chris Donahoe on behalf of the County of Kauai. Also present as a representative is Deputy Director of Planning Jody Higuchi Seigusa. Good morning.
Thank you.
Good morning, Deputy Attorney General Allison Cato, representing Office of Planning. Also here is Ronnie Punakoshi from the Office of Planning. Thank you.
Thank you, Ms. Kato.
Good morning, Bianca Yasaki with Lance Collins here for intervener Liko Kolani Martin, who is also here. Thank you.
Thank you very much. So where we left off was we are hopefully concluding the evidentiary presentations by the petitioner. 2 witnesses left, Mr. Tom Nance and Mr. Ron Agor. Is that correct, Mr. Ewan?
Yes, Mr.
Okay.
Nance is here.
Commissioner Giovanni?
Yeah, I'm trying to recall exactly. I can look it up in the recording, but my understanding was that the first witness, Mr. Bruckner, was going to come back as well for follow-up cross-examination. Is that the case?
I believe we reserve the right to recall the witness if we needed him.
That works.
Is that the same understanding the rest of the parties had? Petitioner?
Yes,
Yes, Chair.
Okay.
So in terms of logistics, would that be at the timing of that be at the conclusion of the 2 witnesses that are coming before us today? Do we have to make the call at that point in time?
We can certainly assess the proceedings at that time to see if we want to recall the witness as was offered by the petitioner.
Very good.
Sorry,
Thank
just to check, Ms. Kato, you share that understanding?
Yes.
Okay, intervener.
Our understanding was that there are certain exhibits that will only be considered if those individuals are available for further examination.
Can you expand on that?
Let me see if I can pull up the exhibit numbers. There were a couple of exhibits that were submitted after the individuals finished testifying. And my understanding was that we were in agreement that those could come in subject to the witnesses being available for further examination as to those exhibits.
Commissioner Okuda.
Thank you, Mr. Chair. Speaking for myself only, I request that the petitioner be sure that at the close of his case, he has put on all evidence that he intends to put on regarding the case. Or to put it differently, I make a request that at the end of the petitioner's case, the petitioner is sure that the petitioner is not going to come back later and say, oh, by the way, I got something else I'm going to raise. My statement is not to indicate any prejudgment of anything, but I just want to be sure that when the petitioner finishes his case and he calls all his witnesses, those are all his witnesses with respect to his case in chief. Thank you, Mr. Chair.
Thank you. Commissioner Giovanni.
Yeah, it's in the testimony that Mr. Bruckner had been in the process of preparing a financial pro forma for the project subsequent to his testimony, and that at least my understanding was that that would be presented that would be completed and be made available to the commission before the evidentiary case from the petitioner is concluded. That's my understanding, and I don't know if we have an update from Mr. Ewan on that.
Mr. Ewan, I'd ask you to respond to Commissioner Giovanni's question first.
Yes, Mr. Chairman, we have prepared and there's a stipulation to submit exhibits 44 and 46. Exhibit 46 is the contract between the petitioner and Okoneku that the commission requested, and we are prepared to move that into evidence. Exhibit 44 is the financial pro forma for the project. We're prepared to have Rana Gore testify as to the pro forma.
Thank you.
Mr. Collins, hold on. Mr. Donahoe.
Thank you, Chair. Just from a logistical standpoint, I had thought I heard yesterday it was the intent for the hearing to this morning to go to 2:30. So I'm just working out logistics with my witnesses. Is that still the timeline?
That is still the timeline.
Okay. Thank you, Chair.
Sorry, to go back to the main questions raised by Commissioners Okuda and Ohigashi, excuse me, and Giovanni. So my understanding was this, and I will ask the petitioner to respond first. Unless the commission chose to ask affirmatively for the recall of Mr. Bruckner, you were going to be done presenting witnesses today and done presenting any additional evidence today. Is that correct?
It appears that it's going to be necessary to recall Mr. Bracken. I could either do it later today or the next time we appear.
And you want to recall Mr. Bracken for what reason?
Well, it appears that there are questions, certainly from Mr. Okuda's remarks. I think that it's going to be necessary to have Mr. Bracken answer questions that the commissioners have.
Okay, and sorry, when I said Bruckner earlier, I meant Bracken. Commissioner Giovanni?
I also said Bruckner when I meant Bracken, so let the record correct that. I believe that the request we made for when Mr. Bracken was about to conclude his testimony in the midst of cross-examination by the commissioners we said might like to recall him for further cross-examination after we heard the other parties' presentation. Is that still possible? So that wouldn't be today, that would be after we hear from the county, the state, and the intervener.
So this is my inclination as the chair. Sorry, Commissioner Okuda, please first.
Yes, my suggestion, and its only suggestion, is that the petitioner put on all his evidence or all its evidence before petitioner closes their case. And let me state the reason why, so that no one thinks there's a hide the ball here. I believe that there may, and I'm just saying may, I make no prejudgments about this, but there may be a motion that is brought about the sufficiency of the evidence and sufficiency of the record. So at least for me personally, I'm giving notice to all parties that if a party has evidence that it intends to present, it's got to present all its evidence before such time that type of issue, for example, some type of dispositive motion is made, and it is going to be too late to say, oh, wow, let me have more time, I'll go fix it. Now's the time for parties who are presenting their case to present their evidence. And when the evidence is closed, that's it. And that's my suggestion and position. Thank you, Mr. Chair.
Thank you, Commissioner Okuda. I might have a follow-up, but I'm going to recognize Mr. Collins first.
Thank you, Mr. Chair. Our position is under HRS 91-10.5, the petitioner who has initiated these proceedings has the burden of proof and the burden of persuasion. And so before any other party is required to put on any evidence, they have to meet their initial burden. So we would strongly agree with the position that the petitioner must put on all evidence that it wishes the commission to consider before any other party is required to produce any evidence. Thank you.
Mr. Collins, while you did it with citations, you took the point that I was going to raise out of my mouth in questioning of Mr. Okuda, just because while Commissioner Okuda directed this to all parties, I want to highlight that there is a particular burden of a petitioner in this kind of proceeding. Is that not correct, Commissioner Okuda?
Mr. Chair, that is correct. That the petitioner bears not only the burden of proof by burden of proof pursuant to the statute, but also the burden of coming forward with the evidence and the burden of persuasion. And if anyone disagrees with that, I'm willing to be educated. But yes, that is the burden that the petitioner faces. And again, I don't believe any of us are prejudging the outcome, but just to make the process clear, if any petitioner fails to meet that burden, then it very well may be that the decision can be made at that point in time. But again, I'm not prejudging anything. I'm not prejudging anything. Thank you, Mr. Chair.
So, thank you, Commissioner Okuda. So there's two issues I want to take up. First issue I want to take up, and actually I'm going to sort of clarify my response to Mr. Donahoe regarding 230. If the way our proceedings go today is that the petitioner concludes their evidentiary portion with or without the commission choosing to recall Mr. Bracken, I had said that we would conclude by 2:30 to allow an hour of discussion on our legislative matters. So we actually would end at 3:30 today, not 2:30. So does that clarify my response to you earlier, Mr. Donahoe?
Yes, Chair, it does. Thank you.
Okay. Commissioner Giovanni?
Yeah, I thought that that was to allow time for the agenda item that we've now moved to 9:30.
That is correct. That's what I'm saying. So we were going to end at 2:30 to allow 2:30 to 3:30 for the agenda item that we're now moving to 9:30. So
Got it.
should we go to things? Okay, so that clarification of my earlier confusing response out of the way. Now to the main subject of discussion that we're doing. It is my intention, and I'm directing the petitioner right now, that after these two witnesses, if the commission does not choose to recall Mr. Bracken at that time, we're going to consider that you have concluded the evidentiary presentation, your presentation at that time. Mr. Ewan? Do you have a response?
I may need to recall Mr. Bracken if the commission chooses not to recall him.
Is he available today? Can you ensure that he is available today?
I have to double check.
Okay, sometime this morning, hopefully in the next hour, while we're hearing from Mr. Nance, I expect to have an answer from you on that, please.
Yes.
Thank you. Commissioner Okuda, your hand's still up, but that might be left over.
Yes, Mr. Chair, I'm sorry, I will lower
No
that.
problem. With that, Mr. Nance, thank you for your patience. Good morning. Can you say something so I can ensure that I can hear you?
Good morning. Can you hear me?
I can hear you, Tom.
Okay.
Do you swear or affirm the testimony you're about to give is the truth?
I do.
Okay. Please proceed with your direct, Mr. Ewan.
Yeah, may I share my screen?
Yes, you may. Thank you, Ms. Ahu.
Please state your name and address for the record.
My name is Tom Nance. My business address is 560 North Nimitz Highway, Suite 213 in Honolulu.
One moment, two issues. One is we now have the presentation correct. We're picking up some echo. You need to mute all but one microphone in the office that you're in. Try say something else.
Yes. Yeah, I'm having, we're on the same mic. Let me see if I can do this.
Now try say something.
Hello?
I'm still picking up some echo.
That's about as well as I can do it.
Tom, can you say something?
Something?
Ms. McManus, is this acceptable for you?
Right now it is. Thank you.
Okay, please proceed.
Mr. Nance, what is your profession and your business affiliation?
I'm a civil engineer with a specialty in hydrology. I'm president of a company doing business as Tom Nance Water Resource Engineering.
Can you please describe your background in hydrology?
Well, I have a master's in civil engineering with a specialty in hydrology, and I have been working in that field since 1972. And over that period of time, if you include wells that I've done internationally as well as here in Hawaii, that probably covers somewhere between 450 and 500 wells developed under my supervision.
I've introduced into evidence exhibit number 21, which is Mr. Nance's resume. Now, Mr. Nance, did you prepare an assessment of an on-site well to provide potable water for HoKua Place?
Yes, it's in a memo I prepared earlier this year in February.
Please describe the testing process used to evaluate the well site proposed as the water source for HoKua Place.
In 2006, a well was drilled in the southwest corner of the project site at about a ground elevation of 25 feet. I don't believe it was ever surveyed more accurately than that. That well passed through overlying poorly permeable alluvial formation, then through a series of clay layers and essentially impermeable Kaua volcanics, and at a depth of about 210 feet below ground, it entered into permeable Kaua volcanic formation. The well was configured to draw exclusively from this lower formation. We tested it for 12 hours, the last 10 and a half hours of which at a rate of about 530 gallons a minute, to demonstrate that if the well were properly developed and properly designed and developed, it could be a viable source of supply for this project. Also earlier this year, I had the drilling contractor on Kauai, Barry Simmons of Oasis. He grabbed the sample, we sent it off to the mainland lab qualified to do testing for all regulated drinking water contaminants. And that testing also demonstrated that the well can produce potable water quality. This well has a small 8-inch casing. Its alignment is relatively poor. There's other construction issues with it. Might want to say for my own benefit that it was not my design or construction. I got involved during the pump testing, but it needs to be sealed with cement according to the regulations of the State Water Commission, and a new well with a proper diameter and proper construction should be installed in place to provide that source of supply. The Bow Engineering has projected the maximum day supply requirement for the project at about 610,000 gallons per day. Kauai Department of Water sizes wells to provide the maximum day supply in a 24-hour pumping day. That would translate to a little over 400 gallons a minute. The testing that we've done in the poorly constructed well without proper development suggested at least 500 gallons a minute is possible. So it's my opinion that, again, if the well were properly designed, properly constructed, developed by surging with a line shaft turbine pump, that it would be able to provide that supply. I didn't mention in my earlier memo on the well, the finding of this relative moderate permeability Kaua volcanic formation at substantial depth below sea level is not a unique one. There's actually 3 other wells that have been developed with a similar depth and a similar configuration, 2 of which are about 4,000 feet to the northeast of the well that was drilled on the site. And one of those is the Kauai Department of Water well. It's called Kapa'a Homestead Well 3. I was involved in its pump test, and it has established that this aquifer that's existing in this formation can be viably developed.
Please summarize the test well results.
Well, as I said, we pumped it at 530. I think I went over that part of it.
Okay. Please summarize your conclusions.
Okay, there's several. One is what I've just stated, is that if the well is properly designed, properly constructed, properly developed by surging with a line shaft turbine pump, it will be able to provide the required supply for this project. Because of the well's depth, it is going to be deeper than the current way that the State Water Commission regulates how far you can drill a well into the aquifer. And because of that, we will have to get a variance to go beyond that. Their current limitation is to drill only to 1/4 of the depth of the basal lens, and we would be drilling to at least half of that basal lens. So we'd need to get a permit for that, and that would have to be issued by the State Commission on Water Resource Management. The other thing is that the well is actually located on the Makai side of what's called the UIC line. The UIC line establishes that injection wells can be installed on the Makai side of this UIC line, but not on the Mauka side. Typically, most drinking water wells are located on the Mauka side of this UIC line.
Mr. Nance, if one moment, Commissioner Ohigashi is you have to leave right now, Commissioner Ohigashi.
I was going to say if it's necessary, I can stay till 9:40 since I'm appearing by WebEx on.
Okay, so
so I'm just curious if it would be going.
Yeah. So so Tom, if we can finish the response to this question, and then we'll break from this agenda item, move to our legislative agenda item, and come back to you.
Okay. The final point I needed to make was describing on the UIC line. This well is located on the Makai side of the UIC line. When we had started to develop drinking water wells in Kahului on Maui, we were putting wells on the Makai side of the UIC line. And up to that period of time, the Department of Health had not developed guidelines for the, what would be needed to certify a well for drinking water use that was on the Makai side of that line. They have that process in place. It's relatively recent, and it's for the drinking water wells that actually I was involved in developing on the Makai side of the UIC line in the Kahului aquifer on Maui. So we would also, in order to get Department of Health certification of the well for drinking water use, we'd have to go through that process as well. It's a matter of informing other landowners around what the restrictions would be on their installation of individual wastewater treatment plants or injection wells due to the presence of a drinking water well. So that does conclude my testimony.
I just had one follow-up question, if I could.
Please.
Do you expect that there would be any issue in getting a variance from the Commission on Water Resource Management?
I don't, but what we would lay out is the process of how we would do it. Essentially, when we drill to that depth that I think we've got sufficient yield, we do what's called a Ctd profile, which would be essentially a running profile of salinity and temperature with depth through the water column. That would be one piece of information that we would provide to the Water Commission to support the variance to go to this depth. The other thing is that in the pilot borehole, we would run an open pilot bore pump test with an inflatable packer so that the pump test would only draw water below the packer in the freshwater zone and present that information. Basically, they'd be looking at, is there going to be a salinity issue if we drill to the depth that we need to get the yield? So basically, the satisfactory results of both the Ctd profile and the open borehole pump test would be our way of demonstrating to the Water Commission that it would be viable at that depth. And the reality is there's a, the working history of the Kauai Department of Water as well at similar depth that has proved to be a viable source of water. So I hope that answers your question.
I have no further questions.
Okay, thank you. So we'll take a break right now. We're going to move on to our agenda item regarding legislative updates from 9:30 till 10:15. Thank you, Commissioner Ohigashi, for sticking around a little past. And then we will return back to our agenda item and for the cross-examination of Mr. Nance. So,
what time do you anticipate returning?
Well, it depends in part on how long it takes us to go through our legislative discussion. Mr. Ordenker, do you know how much your direct presentation is going to take?
My direct presentation is only going to take about 15 minutes, maybe 20 minutes, and then questions by the commissioners.
Okay, so what I think might happen, Mr. Ewan, thank you for your question, is that we might spend about a half hour to 35 minutes on this right now, take a 10-minute break, and reconvene at 10:15. That's my anticipation at this time.
Thank you very much.
Okay. With that, we're going to take up agenda item 8, LUC legislative update, a report by staff on bills passed in the legislature that impact the Land Use Commission. Before we move to that agenda item, let me confirm with Mr. HoKua and Mr. Derrickson if there's been any written public testimony on this matter.
Mr. Chair, this is Riley. No public testimony on agenda item 8.
Okay. Are there any attendees in the audience who wish to testify on our agenda item 8, LUC legislative update? If so, if you are accessing this meeting via Zoom software, use the raise your hand function, or if you're accessing it by telephone, press *9 to raise your hand. Is there anyone who wishes to testify on legislative matters? Seeing none, there's no testimony on this. Mr. Ordenker.
Thank you, Mr. Chair. What I'd like to do very briefly is talk about a few matters that impact the commission and one matter that is what I would call somewhat significant change in structure, but not in operation. There were several bills that passed that sort of memorialize what we've been doing. And that's Senate Bill 873 and Senate Bill 1034. SB 873 relating to contested case hearings allows contested case hearings to be held using interactive technology. And they also can be done as audio only if necessary. This measure takes effect on October 1st, 2021. And you'll see the gap here, which may raise some issues and may cause us to have to go back to the old way of doing things for a little bit before these measures kick in. Senate Bill 1034 relating to sunshine law boards allows boards and commissions the option to use interactive technology for meetings. We submitted some testimony when this was going through because originally they were going to require, the legislature was going to require that the location of each commissioner be noticed. It would have been a little bit difficult if commissioners were going to be joining the meeting from their homes or wherever. So in the end, they allowed interactive conference technology to be used and without having to notice where each one of the commissioners are. In other words, you can continue to take the meetings from your home without worry of the public coming to your house and banging on the door.
Good idea.
The quorum has to be visible and audible to the public. It memorializes what we're already doing. Cutting to the chase. The only difference is that it provides that we'll have to have at least one meeting location open to the public that has an audio-visual connection. This means, from a practical standpoint, that it will become more and more difficult to hold these multi-island meetings. Because my interpretation of this would be that if a petition is on Maui, for instance, there has to be a meeting room available there. If there's a petition on the Big Island, there has to be a room available there. So while it may
You're referring to agendas, Dan, where we take up matters that consider multiple islands.
Yes, well, that was what I'm going to get to. So it may be possible to take up, from a logistical standpoint, to take up a matter that is on Oahu and one on one of the neighbor islands, but mixing various neighbor islands would require staff to spread too thin because we can't operate these rooms without staff being present in case there is an audio-visual problem. So that means that the staff at least will have to travel. This bill doesn't come into effect until January 1st, 2022. So if the governor's executive order expires, we will have to go back to holding meetings on the islands where they're located until at a minimum October 1st, 2021. So it was helpful. And in the long run, we'll be able to do more interactive technology, but it may be that, as I mentioned before, that we have, because of the effective dates of these bills, that we have to start holding hearings on neighbor islands again, or on our hearings in person again. It depends on what the governor decides to do. A couple other measures that are, one other measure that's kind of minor is HB 247 relating to agricultural lands. And what it does is it amends 205-4.5A4 to require farm dwellings to be accessory to a farm rather than used in connection with. There were some efforts in the last legislative session to tighten up the definition of a farm dwelling, so we didn't get these gentleman farms, and which are then turned into TVRs and all the rest of that stuff. But that's a constant battle, and that's really at the county level. That's not our issue. The big change was with HB 1149. And what that bill did was that it extracted the Land Use Commission from being its attachment to the Department of Business and Economic Development, and now attaches us to a renamed Office of Planning and Sustainability. This is very technical in nature. It is a reconfiguration or restructuring of government that is consistent with what the legislature's been doing in a lot of other areas. It wasn't just us that they picked on, although we were kind of the flagship. From an operational standpoint, it's not going to change much as far as the commissioners are concerned. From staff standpoint, we're going to have to erect some safeguards to make sure that we don't violate any legal legal requirements with regard to ex parte communications with OP. I don't think that's going to be a big deal. The bigger problem is one that the commissioners, I don't think we really need to concern themselves with at this time, and that is that one of the things that the legislature did is that it removed our budget line item and put our budget into OP's budget, which is of concern from a fiscal firewall standpoint. We've been in conversation with both Linda, our AGs, and with the AG who was in charge of the budget, who used to work with the Land Use Commission, Randall Nishiyama. And we're going to have to enter into some kind of memorandum of understanding with regard to that, to protect that fiscal firewall. It's our hope that in the next legislative session that we manage to reinstate our budget line item so that we don't have to deal with that problem. The legislators felt that in order to ensure that HB 1149 passed, that they need to make that budget change. So that even if HB 1149 didn't pass, we were in effect going to be in the Office of Planning. That's pretty much what resulted from what I would call a very tumultuous legislative session. One of the other things that happened was that the Office of Environmental Quality Control is also moved into the Office of Planning. And there is sort of an agreement between the director of the Office of Planning and ourselves as to how that will operate as well, that we'll have to memorialize. There was one other measure related to training in Native Hawaiian rights that requires all newly appointed or reappointed members who have not already done so to take the training in Native Hawaiian rights from OHA via UH Law School. You have 1 year to do that. If you don't, the governor's office will be told, and you'll be, if you haven't taken the course within 1 year, you'll be prohibited from serving or voting and may be removed from the board or commission at the end of the regular legislative session. Sort of as a recognition that all commissioners are volunteers and their schedules are not always conducive to their attending the hearings. OHA will record and make available the digital course, and viewing the online version will meet the requirement. And that's all I have, Mr. Chair.
Thank you, Dan, for the overview of, as you said, the tumultuous session and the matters that came out, particularly affecting the Land Use Commission. Members, questions for Dan or comments? Commissioner Okuda.
Thank you, Mr. Chair. Just a suggestion. I think interactive video like Zoom has been a real plus. It's allowed, as we've seen in some other dockets, people to testify while they're going fishing at the dock, pulled over to the side of the road. Yeah. And people can follow along what's going on, even when they're fishing or doing other things or just being at home. So I think this is really good for government transparency and involvement. However, at the same time, if it's at all possible, I think it's really important, as long as it's safe for the community and safe for the participants, that where there are issues are significant and maybe sometimes not that significant, we go out into the community and hold meetings in the same fashion or similar fashion as we've done in the past, because sometimes you really get additional information from people by just being around them. So if it's possible in the future to combine the best that we can from interactive technology, but also if we can try to get back out in the community. I know it's a burden waking up in the morning. That's the great thing about interactive technology, but I've always learned things just by being in the community, having the interactions. I think one very educational thing that I learned, and it was the only way I could learn it was actually being there, was the interaction we had with everyone at the Mauna Kea petition that was held before us shortly before the pandemic. So that's just my comment, a little bit of food for thought. Thank you.
Thank you, Commissioner Okuda. We have been working very hard during the course of this pandemic to utilize funds saved as a result of not traveling to develop a portable system so that when we do go neighbor island, and I agree with you with regard to the value of going into the communities, that we'll also be able to broadcast over Zoom at the same time. So we'll have a sort of a hybridized situation that will allow continued public participation from their boats and their homes and their cars, while also being in the community.
Thank you, Commissioner Okuda and Dan. Other comments or questions, commissioners? Yes. Commissioner Giovanni.
I agree with Commissioner Okuda. I think there's great value depending on the matter at hand, whether we have a Zoom meeting or we have an in-person meeting or we have a hybrid meeting involving both. Just a comment, I hope that we can make those decisions of how we'll conduct meetings in an optimal sense and not just try to do it what costs the least. Sometimes these processes are driven just to save money, and that doesn't give us an optimal result in my view. And then the one quick question I had is about the required course. When I took that course, I did not take it for credit, meaning college credits, which was an option. I just kind of participated in the course. Is that sufficient?
Yeah, yes, it is. That is sufficient. It's for your participation is all that's required. I have to go back and look at the measure. I think that, I don't know what commissioners it would apply to. I think that the effective date may be after your appointment, so it may not apply. I'll have to defer to the AG on that to a certain extent.
It was after, I took the course after I was approved by the Senate for the prior term and
Yeah.
before the current term.
Yeah. Yeah. So I'm not sure whether if you were reappointed and reconfirmed in this last legislative session, whether you'd have to take the course again. No? Oh, okay. Scott says no.
Well, if Scott says no, then, yeah.
I always defer to Scott. I don't know. You know.
Commissioners, are there further comments or questions on this matter? Commissioner Cabral.
Aloha. I agree with both Gary and Dan because we're on a casual situation here. But I would like to think that we could be, I absolutely see with all even my professional meetings in condominium and subdivision management that we're going to be hybrids forever. So I would think that that our staff should look at each of our islands in a location to find a location that is going to be a meeting room or something that's fully equipped with Zoom and not just a Wi-Fi, but a solid connection to the internet. Because when I do go, I'm doing hybrid meetings already. And if I don't have a good internet connection, it can become very problematic. So you've got to understand it's based on how many people are coming in and all kinds of problems. So the better the staff can get at finding, and I would assume state buildings that we go to would suddenly hopefully come up to being this is a great room right here because it's so solid. So whatever, we should be really proactive at finding a location. And then the next question would be, can those locations be something like, okay, my office in downtown Hilo, I'm setting up a new conference room, could probably have during non-social distancing time, probably 20 people could sit in it, you know, close, but 20. And I'm going to have like a good Zoom system. So are those things allowed or permitted or not? Or is it because I'm a commissioner, it shouldn't be at my office? But I think we should find good locations. And I also agree, though, that there are really beneficial times to us as commissioners being together with the people that are coming to testify, both the petitioners and their witnesses, as well as with the general public and their testimony. I think that I have to agree, there's been a lot of different occasions when hearing them and it gives you a more full sense of what's going on than this distance with a screen. So, and then I would assume too that I'm not too worried that between now and October, I don't see our state or our governor releasing us from COVID before October, but it might happen before January. So we need to kind of be prepared for whatever happens. So, and then I think too, I mean, I wouldn't mind, I took that cultural training class a long time ago. So when they do the new one, and even in those 5 or 6 years, I would think that it would be I would like to see it, especially if I can do it on Zoom. And that way there would really update me. So I think that's all my things. Thank you.
Thank you, Commissioner Cabral. Commissioners Chang, followed by Axon, followed by Giovanni.
Thank you, Mr. Chair. I just have 2 points. I really appreciate the fact, Dan, that you and staff, one, your heroic job on getting us on Zoom. And actually, I suspect that LUC, our hearings are probably one of the best with other agencies. But thank you for creating a hybrid opportunity, because I too agree it is really helpful to be in the area where the properties are located. But the Zoom has provided us, you know, people have been able to participate that they otherwise wouldn't have been able to. And so I appreciate this hybrid as I think it is, provides us the best of both worlds. Although I will tell you, I will miss this Zoom if I have to travel. This has been so convenient and permitted me to do so much other work rather than being at the airport. So I guess, we all have to make adjustments. The other question I have is in relationship to the ag legislation. I would like a little bit of further explanation as to, who proposed the legislation? What kind of testimony did you receive? I'm sorry, I did not participate in monitoring the legislation, but if you could just provide a little bit more insight into that, as clearly this commission is taking some strong positions on the definition of farm dwelling on ag lots. So I'd like to have a better understanding of what occurred in this legislative session on that matter.
Mr. Ordenker.
HB 247 was initiated by the Farm Bureau. Who are the introducers?
Study.
Oh, yeah, it was based on a study done by OP with regard to the issue. OP commented, it originated with regard to concerns over CPR projects. The problem originally was that no one was taking responsibility for CPRs. In other words, if somebody wanted to CPR farmland, like we saw out at Cornelia Ridge or something like that, they would apply to the DCCA for condominium property regime, which the DCCA, their only analysis is, are the documents correct? Is there a homeowners association? Does it legally meet the requirements for a CPR? Not looking at zoning or land use issues at all. And then they would send it over to the county, and the county was taking the position that, and I disagree with this, but they were taking the position that, oh, well, the state approved it, so we have to accept it. And there was nobody looking at these things from a land use planning perspective.
So Dan, I'm going to ask you to summarize the status of the legislation.
Okay, so that was basically where the legislation came from. The Farm Bureau was actively involved, and we did not get involved in the discussion, primarily because we felt that we had input into the original OP study and the original conversations with regard to CPRs, and that this was pretty much of a policy call on the part of the legislature. And when it comes to things like this, we allow the legislature to tell us what to do rather than us tell them. And that's kind of the genesis of that bill.
Any follow-up, Commissioner Chang?
No, thank you very much for the explanation.
Okay. Commissioner Axon, followed by Commissioner Giovanni.
Thank you, Mr. Chair. I kind of agree with my fellow commissioners about this hybrid or whatever technology. And, technology is here and it's not going to go away. So it's going to be upon us to change with the times. So my only question is, these technologies comes with a price. It can get expensive, especially if you have to, set up this type of communications each island. So I guess my question is, with this legislation, is there appropriations connected to these legislations? So if we cannot perform our duties because of budget constraints, so what happens?
Well, there were no appropriations directly associated with the legislation. However, because of our cooperation with the legislators, we were one of the agencies who benefited from having our full budget reinstated. So we have all of the travel money that we need if we needed to go back to the old system, which was traveling on a regular basis. As I said, we've managed to use money saved from this current fiscal year that we would have used on travel to create the systems and purchase the hardware and software that's necessary to make it happen.
So to summarize, Dan, I think you're saying we've dealt with it and we've come out okay, but to Commissioner Axon's point, as it might apply to other boards and commissions, there wasn't an appropriation made and that issue remains unresolved.
Well, what I was going to say is that I can't speak to that. I don't know. I did not go into detail on the budget with regard to other boards and commissions.
Any follow-up, Ed?
I guess my question now is if whether LUC or other board, because of budget constraints that, we cannot, well, the boards cannot afford or doesn't have the budget to follow this legislation. So what happened?
Well, as I said, I can't speak for other boards and commissions because we managed to find our way to do it. And we were actually well ahead of the curve on this. We actually started into this process 3 or 4 years ago before the pandemic even hit. But I'm not sure. I mean, we are somewhat unique in the fact that we are required by law to hold hearings on neighbor islands. Not all boards and commissions have that mandate, or not just neighbor islands, on the island where the land is located. Not all boards and commissions have that mandate. I don't know how they would react. I think, in a situation like the Board of Land and Natural Resources or the Commission of Water Resource Management, where they're dealing with property rights and things that impact on development and farming, in the case of the Commission of Water Resource Management, there may be some issues that they have to deal with. I don't know. I mean, I don't know what their situation is. I do know that several years ago, going back to before anyone who was currently on the commission was on, we're looking at budgetary restraints and shortages. And the then director of the Department of Business and Economic Development assured us that they would find the money within the Department of Business and Economic Development to allow us to hold meetings if we got to that point. We never did, but there was an assurance there.
I do want to try and manage this discussion so that we might be able to take a break before 10:15. So
I take a break. I'm taking a break.
Commissioner Giovanni.
Thank you, Chair. I too want to commend the staff for the job they've done using Zoom for our hearings. I point to it with, I live on Zoom these days and nobody does it better. So congratulations and But I do have kind of one nitpicky question that maybe could be looked at. There's a huge difference viewing my Zoom screen when I can see any of the other commissioners up close and personal versus the room that the 6 of you sit in, which is useless. It's just about as good as a audio mic only.
Yeah, that's true.
Even Arnold is hard to see.
I can't tell who's speaking.
Oh, gee, thanks, Chair.
I can't read anything into your emotions. It's just purely an audio. So if there's anything that can be done, just take it a step further to zoom in on who's talking or whatever, that would be really helpful. Just a comment. Thank you.
Thank you, Commissioner. We'll take that into consideration.
That's really true, Commissioner Giovanni. And I think sometimes the counties, which have been in group rooms, I think we've not gotten as much out of their presentations because people are this big when they're talking to us.
Yeah.
Nancy, you had something?
Well, I do have that solution. Like in my hybrids, I take my small computer with me. So I'm looking I'm in the big room like I am right now, but I could turn on here and you would see me as long as I totally mute, then we don't have that reverberation. So if each person in this room had their own screen in front of them, then they would be on that camera. So that combination is very, very, very doable right now.
Thank you, Commissioner Cabral. Commissioner Axon.
Go into it now. Sure.
I just want to comment on Commissioner Giovanni's. What I do really is there's a function speaker view that you can enlarge the person that's speaking. So that's what I use. So just a comment.
Thank you. The one thing I'd like to share on this is that, and this goes to what the comments about being in person. One thing you cannot do in Zoom is really look into somebody's eyes, which is a very particular kind of human emotional exchange. And whether it's a witness or whether it's a petitioner, I have found sometimes in my 6+ years of service on the LUC that somebody looking directly at me when they're testifying has a particular kind of impact that is not available in this virtual world. So I do err on the side of what Commissioner Okuda has said, that there are certain matters and others. There are certain matters where we really should be in person, if at all possible, at least having that option available on the island on which an important matter is being discussed. Is there anything more on this right now from the commissioners or from Mr. Ordenker? If not, let's go into recess until 10:15 when we'll resume discussion of the HoKua place matter. It's 10:20. I'm going to suggest to the commissioners that we start up, and we are also going to lose Commissioner Dan Giovanni at noon, from noon to 2. So it is 10:20. Perhaps what we will try to do is go about an hour, 10 minutes to 11:30. Around 11:30, take a break for lunch. From 11:30 till 12:15, resume after that if needed, and proceed on our day. Does that sound acceptable to the parties?
Yes.
Okay, I see nodding heads. Thank you. Okay. Sorry, Mr. Yuen, you were raising your hand? Okay, just gesturing. Okay, so you were done with your direct. We'll now start with Mr. Donahoe's questioning of Mr. Nance.
Thank you, Chair. Deputy County Attorney Chris Donahoe. Good morning, Mr. Nance.
Good morning.
You raised a lot of scientific points in your presentation, so I wanted to kind of ask you some non-scientific questions, kind of break it down so then I can better understand some of the issues, okay?
Sure.
So regarding water resourcing, does the County of Kauai have different issues with regard to water than, say, Oahu or other islands?
Well, to some extent, Kauai is different hydrogeologically as being the oldest with 2 major volcanic series eruptions. So in that respect, it's different. And the reality is this second formation called the Kaua volcanics is very heterogeneous and unpredictable. And so in comparison to example, Kauai versus any of the other islands, typically Kauai, about 60% or so of the rainfall runs off the surface water, whereas on the other islands, it's probably only 20%. So hydrogeologically, Kauai is different.
Okay. And then some of the concerns.
1 second, Mr. Donahoe. I just want to note for the record that right as you were starting your questioning, Commissioner Ohigashi joined us.
Oh, okay, sorry.
Did I miss anything? Did I miss anything, Mr. Chair?
Nothing substantive other than our schedule.
Thank you.
May I continue, Chair? Thank you, Chair.
Please.
So some of the concerns being raised with the petitioner's proposed project are productivity, namely the water supply and how much will be needed for the project, and the availability of a new well source. Is that fair to say?
Yes.
Okay. And so the 3 main issues to consider when looking at water are source, storage, and transmission, correct?
Yes.
Okay, so with regard to the proposed development, the analysis would be to see if the current water system on Kauai has enough source, storage, and transmission capacity to be able to serve the additional water needs of this proposed development, correct?
Well, first, I don't believe that's the case, but that's not exactly what I've been prepared to testify on. I'm testifying on the viability of an on-site well to provide the adequate supply. So its potential connection to the Kauai Department of Water System is not something that I've looked at for the project.
Okay, so regarding the water supply, you testified that the project's maximum day supply requirement is estimated to be 610,383 gallons per day.
That's a calculation made by Bow Engineering.
Okay, and then applying the Kauai DOW design requirements, the project supply requirements, that would translate to the well pumping capacity of 424 gallons per minute.
Yes.
Okay, and so in order to meet this demand, what you're recommending is that a 500 gallon per minute well pump capacity be installed, correct?
That's one possibility. If it's, my understanding is that both a private water system and a system dedicated to the Kauai Department of Water are still, I'm not sure that a decision has been made about that, but the 500 GPM pump would certainly supply it if it were a private water system. If it's connected with a county, Kauai Department of Water may want a certain amount of its capacity of the well reserved for themselves rather than the project.
Okay, but is it your position though that a properly designed and on-site well will be able to produce the necessary water supply, drinking water supply for HoKua Place?
Yes, that's my conclusion.
Okay, and then the proposed well, as you testify, would be 300 feet?
Well, the actual depth would depend on conditions encountered. I don't imagine that we'll go beyond that. Might go a little short of that if we got sufficient yield penetrating to a shallower depth than that.
Okay, and then
decision that you make based on the information being provided as we're drilling.
Okay, and then have the petitioners been attempting to locate the proper new well source to service the water needs?
Could you, I don't understand the question. Could you try to repeat it?
Okay, is it your understanding that there have been attempts made by the petitioners, the developers, to locate a proper new well source to service the water needs of the project?
It would be in the very near vicinity of the well that was drilled on the site.
Okay, and then do you recall recently having a conversation with Michael Hinazumi from the county regarding the status of the well source?
If you're referring to a phone conversation 2 days ago, yes.
Perfect. Yes, that's what I'm referring to. And my understanding is that originally a well source was located, like you just testified to, correct?
Well, an exploratory well was drilled, yes.
Okay, so the drilling commenced on that well source.
That's well back in 2006.
Okay. Is it true that the Commission of Water Resource Management, or CWRM, did not approve of the well?
That's my understanding. Yeah, they asked that it be backfilled according to their standards.
Okay, and by backfill, is that another way of saying that the well is required to be abandoned?
Sealed and abandoned, yes.
Okay, what's the process for doing that?
You apply for a permit with the Water Commission to seal the well, and in this case, you fill it with cement by a licensed drilling contractor, and then he files a well abandonment report and submits it to the Water Commission. You have to have prior approval, do the sealing, and then an abandonment report after.
Okay, and to date, are you aware that the petitioners or the developer has not completed the original well abandonment?
That has not been abandoned, correct.
Okay, and so it's my understanding, and correct me if I'm wrong, is it true that the abandonment of the original well is required to be completed prior to drilling another well?
I'm not sure that that is the case. I might recommend to the commission that we leave it in place until we do the new one, so we can actually monitor from the existing well as well as the new well. But if the commission says seal that one first, then we would do that.
Okay, and if the CWRM required that, then that would have to be done first before the drilling of any additional wells.
I'm not sure that's the case. It may be, but I'm not sure.
Okay, fair enough. And to date, has there another proposed well source to service HoKua Place? Has it been located yet?
Well, not with exact precision, but as I say, it would be very near to the well that had already been drilled.
Okay, but no specific location.
Well, if you're talking about meets and bounds description, that's correct. That wouldn't have that.
Okay. And then, and after completion of the abandonment of the other well, is it your understanding that it's the owner's responsibility then to locate, design, and drill the new well source? So it's on the developer to do that.
That's correct. Yes.
Okay. And then, since there hasn't been a new well source formally located, designed, and approved for drilling, this could potentially extend the proposed timeline for completion of HoKua Place, correct, with respect to water?
If the well's not done, sure, absolutely.
Okay. And did you assess the cost for locating and constructing a new well source?
I have not done that, no.
Okay. Are you in your experience, are you able to testify and talk about how much it may cost to develop a new well?
I'm not sure I understood the question. Could you try to repeat it?
Can you talk about how much it may cost to develop a new well, if you know, if it's in your realm of expertise?
It's on the order of $500,000.
Okay. And with that additional cost, could that increase in cost in coming up with the funding to do that? Could that also increase the development timeline and overall cost of the project?
Well, I don't know about the timeline because I don't know the project's timeline, but certainly it would be part of the cost.
Okay. And then will you be involved in monitoring the well drilling to ensure that the state laws are complied with?
If asked to, yes.
Okay. And then would you also be, if asked to, be responsible for the testing, the capacity and quality of the well source to ensure compliance with the DOH standards?
Again, if asked to, yes. I mean, typically I would design, oversee construction, direct the pump testing, file all the results. That would be my typical involvement in developing a new well.
Okay. And what are some available options if, for instance, the current new well source doesn't have the capacity or other issues come up in the permitting and development of it?
They'd have to seek another source somewhere else. Whether we tried that as a second well on the same property is one proposition. County is currently involved in developing new sources such as Kapa'a Homestead Well 4, which I'm involved in. So it would be one or the other of those ways to provide sufficient supply.
Okay. And then are you aware if there's a plan to use the 2 county Department of Water reservoirs?
I have not been involved in that.
And is it your understanding that also, talking about transmission lines now, that the developer would be responsible for installing the transmission lines for service to the development?
Typically that is the case, but I want to emphasize, I have not been involved in that part of this project.
Okay. Are you familiar with did you analyze the cost at all for installing the transmission lines, or can you speak to that in any capacity?
No, I cannot.
Okay. Do you know if the developer included, did you get a chance to review the overall cost prediction for the infrastructure budget in this case?
I've not seen it and have not obviously not reviewed it.
And are you aware of if there was any agreement, if you know, between the petitioners in this case in the County of Kauai, DOW regarding water source, storage, or transmission reached by the parties?
I do not know that.
And however the water is sourced, the proposed development is going to result in a new water use or an increase to existing water use in the area, correct?
Correct.
Okay. How would you describe the end use of the water, be it private, commercial, or domestic?
It's municipal, it's drinking water. There'd be some landscape irrigation, but primarily for drinking water use.
And then, and you understand that private uses of water are not protected as a public trust purpose, correct?
I'm not sure I understand the question. You could try again.
I'll just ask you another question. Have you analyzed the various uses of water and how that the uses may affect other public uses?
In this particular case, no.
Yes. Okay. What have you done that in other cases?
Probably other islands. I can't recall specifically at the moment.
Okay. What was the when you analyzed it in the other cases, what was the reason that you were asked to analyze the various proposed uses of water and how they could affect other public uses?
It was primarily whether in drawing groundwater from a well, we were going to impact stream flow.
Okay. Okay. Is there a reason why, or if you know why you weren't asked to do that in this case?
I have no knowledge. Don't know. Can't say.
Okay. And then have you analyzed the various proposed uses of water and how they could affect other private uses in this case?
Not specifically, but I don't believe any other private uses would actually be impacted.
Okay. And again, you've analyzed how it would affect other private uses in other cases, though.
In the manner that I just indicated.
Perfect. Perfect. Did you study the effects that any future well source may have to other water systems and sources on Kauai?
I'm not sure I understand the question. Could you try again?
Okay, so if there's a well source, it may or may not affect other water systems and other sources of water on Kauai, correct?
Potentially.
Did you study the effects that that may have on those other water systems?
Not specifically, no.
Okay. Do you feel it would have been important to have been asked if somebody asked you to study that?
To be honest, because we're drawing water from a deep aquifer that's confined by overlying formations, the reality of pumping from this aquifer is not likely to impact even surface water, much less other groundwater uses.
Okay. Have you consulted or discussed any of these potential water issues with the CWRM?
I did have a conversation with Roy Hardy of the Water Commission, specifically on the status of the well that's Makai of this property. I think it's a 4-inch cased well that's relatively shallow, limited yield, just to find out if it was still being used and what its status was. And Roy told me that it wasn't in use and they have asked the owner to seal it, similar to the request for the on-site well.
Okay. Okay. Did you study the effects that any of the possible well source locations and well sources may have on any downstream uses?
Not specifically, but as I say, if we put a well in this project, it's relatively close to the shoreline. It's not likely to affect any downstream uses based on the depth that we are drawing the water from.
Okay, but to your knowledge, you weren't asked to study that, and it potentially could have an effect. You just don't know because no study was done, correct?
I was not asked to study it.
Okay. Are you familiar with Kauai's water use and development plan?
To be honest, not really.
Okay, fair enough. In your opinion, is the proposed use of water, what's being proposed for the project, reasonable and beneficial in relation to other public uses?
I believe it is.
Okay. Same question regarding private uses. Is the proposed use of water for the project reasonable and beneficial in relation to other private uses?
I believe it is.
And will the proposed uses harm any protected uses under the public trust? For instance, would the proposed use harm the maintenance of waters in their natural state?
I don't believe it will.
Okay. Will the proposed use harm the protection of domestic water use?
I don't believe it will.
Okay. Will the proposed use harm the protection of water in the exercise of native Hawaiian and traditional and customary rights?
I don't believe it will, but I have to sort of say that in a very cautionary manner. I'm not aware of any downstream traditional cultural practices using water. But as I say, this is a very deep aquifer that discharges into the ocean at depth offshore, not likely to affect anything in the nearshore area.
Okay, but specifically with that, the exercise of native Hawaiian traditional and customary rights, you didn't particularly specifically study that.
That's correct.
Okay, and would the proposed use harm the reservation of water set forth in the state water code?
As far as I'm aware, it will not.
And then what is the proposal to accommodate the public's use, access, enjoyment, and resource protection, if you're aware of any? What's the plan?
I'm not aware of any.
And then what actions are proposed to mitigate any cumulative impact to public trust purposes that may occur if the proposed use is to be approved?
I'm not aware of any.
Okay. You weren't asked to do an analysis or come up with potential mitigations if there was an issue?
I was not.
So in addition to the State Land Use Commission, are you aware, isn't it true that that a public trust analysis will also have to be conducted at the county level before there's approval?
I'm not aware of that.
Okay. Are you aware that, actually, that's all the questions I have. Thank you so much, Mr. Nance. Thank you, Chair. Thank you, Commission.
Thank you, Mr. Donahoe. Ms. Kato.
Hello, Mr. Nance. So for the existing well on the property, my understanding is that you came onto the project after that was already constructed. Is that correct?
That's correct. Just to oversee and direct the pump testing of it. Correct.
Do you know if that well done solely for test purposes, intending to be sealed?
It was a contract by Greg Allen to the driller Marcus Franson, and I don't know any of those details. So I can't really speak to that.
Okay. But I mean, and you testified earlier that that existing well is unusable for this project. Is that correct?
Yes, absolutely.
Okay. So my understanding is that there are two alternatives for the water supply being considered, and that both involve the construction of a new up to standards well constructed by petitioner. Is that correct?
Yes.
Okay. For my understanding, what triggers the need for construction of a new well versus using the existing public water system?
I haven't had those discussions with the Department of Water, but I assume we're doing that because the Department of Water does not have a source to supply this project.
Okay, so your understanding it's likely due to lack of capacity.
In the Kauai Department of Water system, yes.
Okay, are you aware of any planned water system improvements by the county?
I'm working right now on Kapa'a Homestead Well 4. That's what I'm aware of that's going on.
Okay, I do think those, I guess, any improvements, do you think the situation has changed where the county may be able to provide water without the new well at all?
I can't speak to that. I haven't had conversations with Department of Water.
Okay. So the pump test for the existing well, the exploratory well, that was done in, my understanding is that was done in 2006, correct?
Yes.
Was there any more recent tests done since that time?
Earlier this year, I had the drilling contractor, Barry Simmons Oasis. He put a small submersible pump in the well, pumped it for a while till it cleaned, took samples. We had those FedExed overnight to the mainland lab and analyzed for all the regulated drinking water contaminants.
Okay, and the results of that test were that the water was sufficient, right?
It will meet the water quality requirements to be certified for drinking water use.
Okay. Regarding the new well that you're recommending be constructed according to standards, that's going to be very close to the existing well. Is that correct?
It will be in the near proximity, yes.
Do you foresee, are there any foreseeable issues with the fact that it is in a different location?
In a what location?
Well, that it's going to be in a different location because it hasn't been started yet, that process. So do you have any, are there any foreseeable issues with the fact that a new well is going to be drilled in a different location from the existing well? Like, will there be any changes, do you think?
Well, it is true that Kaua volcanics change dramatically from location to location, but we will be so close to the existing one that I'm pretty comfortable that what we see as the potential yield from the originally drilled well will be applicable to the new well.
Okay, so it's unlikely to be different from what you've seen with the existing well.
Right.
Is that correct?
The other thing is that, as I indicated earlier, there are 3 other wells that were drilled previously, first in 1986, then 2004 and 2005. And they all hit this same source, same piezometric head water level, and all were, in terms of yield, were successful.
Okay. So you said that the test well was drilled to 260-foot depth, and your recommendation for a new well is 300 feet. Is that correct?
As I say, we would, when we apply for a permit, we would indicate potential depth of 300. If during the process of drilling, when you hit formations that are yielding water, you are actually airlift pumping out of the hole. So if we got to a point short of 300 where we thought we had the yield, we'd stop at that point rather than continue on.
Okay. Are there any foreseeable issues with the fact that you may have to drill deeper? In the case if you drill down and you don't hit it for a while, would you need to keep going down?
I can't eliminate that possibility, but we'd have to go back to the Water Commission to get permission to do that.
Okay. So I want to clarify about the requirements for the project. You mentioned that the requirements for the project for the daily supply is 610,000 approximately.
It's what we refer to as a max day use. The average use is that number divided by 1.5. It's around 407,000 as a year-round average.
Okay, is that, when you say the project, is that specifically the requirement for HoKua Place? Or was that intended to, is that well intended to supply HoKua Place plus the ag lots that are to the west of the property, of the petition area?
I wasn't involved in that calculation. It's a question for BOW engineering rather than me. I assume it's for both, but I don't know that.
Okay, is it your understanding that the well is intended to supply both locations?
Again, I really haven't been involved in that part. I'm just sort of focusing on the viability of a drilling well in this location to provide that kind of supply.
Okay, so your opinion that the 500 gallons per minute pump will be sufficient for HoKua Place, that is, you're specific to HoKua Place?
If HoKua Place was supplied by a private water system, yes.
Mhm.
If it's connected to the county system, the capacity of the pump would be subject to negotiation between the parties.
Okay, so in determining whether a new well would be sufficient for HoKua Place, you did not consider whether that well would be required to supply the ag lots that are outside the petition area. Is that correct?
I'm just talking about the viability of the source to provide that quantity of supply. That's what I am here to discuss.
For HoKua Place?
Yeah.
Okay. Okay. All right, so just to be clear then, so it's your opinion that a properly designed new well would produce enough water supply for HoKua Place at full build?
Yes.
Okay, thank you. I have no more questions. Thank you.
Thank you, Ms. Kato. When you lean forward, by the way, we lose about half of you. So,
Sorry, I tend to hunch.
Okay, intervener. Give me a sense, Ms. Isaki, will it be you? How long
Yes,
do
it
you
will
think
be.
you have?
If I get, my questions are all yes or no, I think I could probably do it in half an hour, maybe a little less.
Okay, let's give it a shot. Please go ahead.
Okay, thank you so much for being here, Mr. Nance. Your testing was done recently, so it's not in the EIS, which was approved, I think, in 2019. Is that correct?
The water quality testing, that's correct. It was done earlier this year.
Great. And sorry, and you clarified, I think, that the 500 gallon per minute pumps might be enough for private system, but not county. Is it a common practice for the county to require a third of water reserved as credits that it can use for other developments?
I can't speak to the Kauai Department of Water's criteria. Other municipalities have different percentages. One of them being 1/3, that's the Big Island, but I don't know what the Kauai Department of Water requirement would be.
Okay. And you mentioned that the county may lack a volume of water resources in response to the OP's question about hooking up to the county system, correct?
That's my understanding, but as I say, I haven't really been involved in that part of this project, so I can't really speak to it directly.
Is this, was the test borehole and the proposed well for HoKua Place in the Lihue Basin? Sorry, did I lose you? Hello?
We're still hearing you.
Oh, okay. Oh, yeah, that was the end of my question. Is it in Lihue Basin?
Can the witness hear the questions? Mr. Ewan, can you hear us?
I think we did not hear the entire question.
Okay, if you could repeat the question, Ms. Isaki.
Is the test borehole and the proposed well in the Lihue Basin, what's considered the Lihue Basin, if you're familiar with the term?
It might be in the northern part of the Lihue Basin,
Are you aware of wells in the,
so I'm not really specific to it.
are you aware of wells in the Lihue Basin that have had reduced productivity in recent years?
Yes,
Is Nono Well B one of those wells?
it may be.
Is Kilohana Puhi well one of those wells?
I wouldn't be familiar with that.
Are you familiar with Kalepa wells falling water levels? I'm sorry, Kalepa well.
Yeah.
Oh, okay. To clarify, I was referring to Kalepa well 10, and that's still yes. Is your answer still yes to that?
Yeah, both Kalepa and Nonu actually are drilled into a different formation. They're drilled into the exposures of the Waimea volcanics, and the compartments they're drilled into are very small, and essentially they have been overpumped relative to what can be supplied in that very small specific area.
Thank you. If the is it your understanding that there's a possibility that the HoKua Place well could be connected to the KDAO, the county water system?
I assume that's one of the possibilities being considered.
Okay, and the county water system, if it's connected to other water sources, correct?
Yes.
So if the HoKua Place, for some reason, ran dry, it would have access to the county water system's other sources.
It's be up to the County Department of Water.
Okay, thank you. And are you familiar with the Water Commission's 2004 well construction and pump installation standards?
Generally, yes.
And you'd agree that those standards require 48 hours of testing for a 500 gallon per minute non-public supply well?
Yes.
But there was not a 48-hour pump test done on the test borehole, correct?
That's correct, because there was, from my perspective anyway, no intention of actually using it. We just wanted to evaluate what the capacity would be, but there was no, from my perspective anyway, given what I knew of how the well was constructed, there was, from my perspective, no way that that was going to actually be put into use.
Okay, but did you recommend a 48-hour constant rate test pump for that test borehole?
For the purpose that I was seeking to establish the viability of the source, it was not needed.
Did you recommend a 48-hour constant rate pump test?
No, we ran for 12 hours.
Did you recommend 48 hours?
No.
I think you've asked him that 3 times and he's answered no twice.
Okay, can I share my screen? I want to show exhibit number interveners 97. Is that permitted?
Yes.
Okay. Here. I hope that we are all looking at interveners exhibit 97. This is from, I think, sorry, I have the PDF number at the bottom, PDF number 47 or PDF page. Could you read, if you can see it, from 12 o'clock on August 9th, Wednesday?
I can read part of it.
Please do.
What's the question?
Could you please read on August 9th, the Wednesday, so it's on the left-hand side of the page, starting at 12 o'clock, Tom wants to ream well, and just finish out what the rest of it says. I'm just asking you to read the exhibit.
Yeah, to ream out to 12 inches, put 12-inch pipe to 170 and test for 48 hours. They didn't do that.
Oh, okay. So, and there's also a note underneath that says TN recommendations. Is that correct?
That's what it says. I mean, I didn't write that. That's Marcus Branson, I assume. But they didn't do that.
Correct. So you did not recommend it, or you did recommend 48 hours?
We're talking about 2006, so I can't really recall, but the realities are if they were to develop it as a viable source, casing would need to be 12 inches, borehole would be need to be reamed to 19 inches, and a 48-hour test done. That's not what they did.
Correct.
They did an
Okay.
8-inch casing, and you know, when I put my instruments down as crooked as a dog's hind leg, there was no way this thing was going to be a viable source of supply.
Okay. And you said that there's a possibility the well could become linked to the county's water system, right?
Not this well.
Oh, sorry. The new well.
The new well, yes. That's my understanding anyway.
Do you know how many hours of constant rate pumping are required for a public supply well?
If it's going to be conveyed to Department of Water, you need to go 96 hours.
Thank you. And okay, I do have one more thing I want to share, if this is okay. And this is actually from, it is Petitioners Exhibit 23, the water PowerPoint that Nance just showed. It would be okay for it to show one page from there? Okay. So this is from your presentation, and is it correct that you're proposing to put the well in amid some springs?
I can't really, I think I have a copy of that here. Let me see if I can.
Page 5, I'll try and make it bigger.
Okay, that shows the location of the well that was drilled. And we would put the new well very close to that location.
Okay, thank you. And it does say that those are springs in this area, correct?
Yes, the USGS cloud map says that.
Great. Okay, I'll stop my share. And I know you said that you told the county you were not asked to evaluate if there was interference with the streams or spring, correct?
I haven't been asked to do that, but the realities are it's likely to be a requirement of approval of a permit to drill a new well, I would assume.
Would it also be likely a requirement to test if there's interference with other wells in the area?
Well, the closest well is about 4,000 feet away. You're not likely to see much of anything.
Okay. And is it correct that, or did you know that the Water Commission noted that there was a lack of an evaluation of potential interference with wells and streams and assessing the test borehole?
I'm not aware of that.
Okay. I want to move on to your aquiclude conclusions. Your presentation asserted that at 80 to 210 feet of depth, there's an impermeable volcanic rock and clay, which functions as an aquiclude, correct? In
Yes.
regard to the 2006 well.
Yes.
Were you aware that the Water Commission reviewed the well drilling logs for that well and concluded there was not an aquiclude at that depth, at least?
I'm aware of that, and I absolutely disagree. And we just went through a similar analysis for Molawaka 1. It's unfortunate that the Water Commission staff just hasn't had the experience of drilling through the Koloa volcanics. And you've got layers of poorly permeable lava, layers of mud. And the realities are that you get small little perchwater bodies on some of these impermeable layers. And the assumption that there's collective permeability vertically through it is absolutely incorrect.
Are you aware that?
Analysis.
Are you aware that the Water Commission believed that it's possible that that recharge during your 10.5-hour constant rate pump test may be from the strata between 86 to 210 feet?
I'm not aware of that, and I would call that assertion without value.
Okay. And you're aware that the petitioner or one of the petitioner's other consultants or poured 212 bags of cement into that borehole?
I'm sorry, I didn't quite get the question. Did you try again?
Are you aware that the petitioner poured 212 bags of cement into this test borehole?
No, I'm not aware of that.
Okay. Are you aware of whether the interval between 180 and 210 feet below ground was it cased to prevent mixing between deep and shallow waters?
It's currently only cased for a portion of that.
Are you aware that the Water Commission was concerned that there is currently because it's not properly constructed and not properly sealed, that may allow for wasting and mixing of deep and shallow waters?
They may be of that opinion, and I mean, the amount of possible leakage from up above is pretty insignificant if it occurs at all in that well. And certainly when we construct the new one, it would be done properly. That's among the reasons why this thing is absolutely not usable.
And although it's not usable and not used, the Water Commission, please tell if you're aware that they thought that this posed a significant potential for leakage to occur into commingling between groundwaters of different formations.
That could be their opinion. I would disagree.
Okay. And to your knowledge, the entire interval has not been cased, only a part of it, correct?
That's correct, yes.
And you testified earlier that it had not been, this test borehole had not been abandoned, correct?
It has not been yet. That's correct.
Okay. I'll move on. And the test borehole, was it plugged? So you said it was not plugged. Was there a UIC permit obtained for that test borehole?
A UIC permit?
Yeah.
What you underground injection control permit for that well?
Yes.
No, that would be
for the test.
That's for disposal wells. That's not for supply wells.
Okay. Thank you. I just wanted to get your opinion on that one.
Currently.
Is it because that water master plan was for 50 farm dwelling units and like a goat raising operation and not HoKua Place?
I can't speak to that. I don't know what the current master plan is. Haven't been involved in that.
Okay. Sorry, one more question. Your water master plan that you said you worked on before, was that for the 50 farm dwelling units and a goat grazing operation?
It's 2012. I can't recall exactly. There were several versions. One was just for an agricultural use. Another was for both potable and agricultural use. So there was more than one version of a master plan at that point in time.
Excuse me, Ms. Isaki. Can you hold on, please? I think we lost the chair. Hold on, please.
Oh,
no,
sorry. I got dropped off briefly during the question. I have no idea why.
How shall I proceed? I actually asked my last question. It was about the water master plan.
I heard that question. I heard that question.
And I was asking.
Go ahead.
I asked about a goat raising operation, and that was actually my last question.
Okay. I believe I.
Thank you.
Thank you. Okay, commissioners. Who would like to ask questions of Mr. Nance? Commissioner Giovanni.
Thank you, Chair. Mr. Nance, I only have one question, and it has to do with your testimony about this. Your expectation is to drill the new well, Mackay, of the UIC line?
Yes.
and that you would need to obtain a variance or an exemption to allow that to happen. Is that correct?
Yeah, the well, whether it's for a private system or for a county department of water, needs to be certified for drinking water use by the State Department of Health. Because it is Mackay of the UIC line, the underground injection control line, it has an added procedure to alert landowners in the near proximity of the well that once the well is certified for drinking water use, there are prohibitions for installing either an independent wastewater disposal system or an actual disposal well within certain radiuses around the well. So you have to go through a public notification process, alerting landowners that this is what's going to happen, and this is the implications of it becoming a drinking water well.
And I believe you also mentioned there were 2 tests that had to be accompanied that were and approved for that exemption. Is that correct?
I don't know what you're referring to.
You said there were 2 tests that had to be submitted with the request for the exemption, for the variance.
Okay, that variance is for the depth of the well, not related to the UIC permit. You want me to go over that?
No, I'm particularly interested in being on the wrong side of the UIC line.
Okay. The 2 tests I was referring to in getting a variance were for the depth of the well drilled, not for its location, Mackay of the UIC.
Okay, thanks for clarifying that. Do the neighboring landowners have the option to protest or to request a contested case or whatever if they disagree with?
And my understanding is that they do, yes. They need to be notified personally by letter contacting them, as well as publications in the newspaper and that kind of thing. And they are asked to, raise an objection because this, that, or the other thing makes an unreasonable imposition on whatever they had wanted to do with their property.
And I understand your opinion that it's very, very likely, if not almost assured, that process will work out to the favor of the petitioner and they'll be allowed to drill the new source well below the UIC line. That's your opinion.
I can't predict that. When I think you're sort of confusing that with whether we can get permission from the State Water Commission to drill deeper. I don't know what the neighboring landowners, how they would respond in this notification process.
Okay, that leads me to my real question. My real question is, in the whatever event that the petitioner is not allowed to drill a well on the wrong side of the UIC line, meaning on the Mackay side of the UIC line, is there another option for a source well for this property on the side of the UIC line?
Hang on, let me check. Where it was. It's pretty much the whole property is on the Mackay side of the UIC line. So they'd have to, if that were a problem, they'd have to find an adjacent piece of property that they could drill a well on that would be on the Mauka side of the UIC line.
How far away is that?
It's not too far. I mean, it's probably within couple thousand feet at the most from the property.
Okay, thank you. That's all I have. Thank you, Chair.
Thank you, Commissioner Giovanni. Commissioner Okuda.
Thank you very much, Mr. Chair. Just a couple questions, Mr. Nance, and to frame the question, the reason why I'm asking these questions is to determine whether or not we have a problem here under what's commonly called the Kuilima case. That's Unite Here, ! Local 5 versus City and County of Honolulu, 123 Hawaii reports at 150. That deals with the issue of the need of supplementation of environmental impact statements, and frankly, whether or not the initial environmental impact statement might be adequate enough to even allow an agency to move forward. My first question is, were you involved in the preparation of the final environmental impact statement?
No, not at all.
Have you reviewed the final environmental impact statement?
I've looked briefly at some of the sections.
Were you looking at sections that dealt with water, water resources, and impact of the development on water or water resources?
I think I briefly looked at that, yes.
In your review, however brief it was, of the final environmental impact statement, did you see anything in the final environmental impact statement which you can specifically point out to us so that the record is clear, which included the matters that were discussed in your questioning by the County of Hawaii's, the County of Kauai's attorney today, the Office of Planning attorney today, or the intervener's attorney today? Can you point to where in the final environmental impact statement those issues were discussed?
I can't. I don't have the EIS here, and my review of it was very brief. I was not involved in its preparation.
Can you recall, to the best of your knowledge, any such discussion of those water or water resource or water impact issues that the three councils questioned you about? Can you recall any such discussion in the final environmental impact statement?
I think a number of those things that have been raised were not addressed in the EIS.
You have been involved previously in your professional career, which is amply documented in the resume, made part of the record. You have been involved in the preparation of draft environmental impact statements and final environmental impact statements, correct?
Yes.
Given your experience, are you troubled in any way, no matter how manini or small you might be troubled, but are you troubled in any way that these water issues were not discussed in the final environmental impact statement?
Troubled is a kind of a strange word because I haven't been involved in that part of the progress. But, you know, had I been the author of this section, I would have written it in a different and far more detailed way.
My last question deals with the process of decision-making and the duties which the law imposes on us as commissioners of the Land Use Commission. You do agree, we're not like the legislature. We can't just make decisions based on our personal preferences. We're required to follow the law strictly as the legislature has passed a law. You agree with that?
I really can't speak to that. I'm a hydrologist and I deal with groundwater and wells and so forth. So I can't really speak to that.
If we were just to look at the final environmental impact statement, do you believe there is sufficient information in the final environmental impact statement for us on the Land Use Commission to make a reasoned decision with respect to the impact and effect and availability of water for this project, or is there not sufficient information?
I didn't review the EIS for that purpose. I was really just reviewing it to see if they had in some way or other misrepresented both the existing well that was drilled and the proposal to drill a new one. But I didn't review it for, gee, is this complete or whatever. So I really sort of don't feel comfortable responding to that.
Okay, well, this actually will be my final question. Whether you feel comfortable or not, based on your experience as documented in your resume, which is part of the record, can you point to anything in the final environmental impact statement which, for example, I or we as commissioners can believe that there is a sufficient discussion in the final environmental impact statement with respect to the topics that you testified on today?
As I say, I didn't review the EIS from that perspective. I think what I presented in the testimony today represents my opinion about the viability of the well being successful on site.
And your opinion, as you testified today, is not stated in writing in the final environmental impact statement, correct?
I think that is correct, yes.
Thank you, Mr. Chair, and thank you very much, Mr. Nance. No further questions.
Thank you, Commissioner Okuda. Commissioners? I, of course, have questions for Mr. Nance, but don't want to jump in line. Commissioners? Okay. Hi, Tom. And forgive me if some of my questions are a little bit repetitive of some of the questions that, oh, Commissioner Axon. Commissioner Axon.
Sorry about that. I wasn't gonna ask it. I just have a simple question to Mr. Nance. You know, I value everybody's experts recommendations. I guess my question is, as you have said that, you know, there's not going to be enough supply of water just through the county, and it will need a private a well to accommodate this project. So is it your testimony that given with a county, or whether a county or private well, there would be sufficient amount of water to supply this project? And in addition, would there be any adverse effect to the environment if the petitioner proceeded with this drilling? And also, well, let me I'll let you answer that question first, and then I'll ask the next question.
Not sure. Are you asking if it's my opinion that the well will be able to provide sufficient supply for the project? Is that your question?
Yeah, that's correct. I just want to kind of confirm that your testimony is you testifying that there would be sufficient amount of water to supply the project, whether it's county or in addition to the private well.
Yeah, my testimony is that, you know, by developing a new well on this site properly, there will be sufficient supply.
When doing the additional well or drilling another well, would there be an adverse effect to the environment?
I don't believe so. We'll be drawing water from more than 200 feet below sea level. And that water is hydraulically connected to the ocean at depth offshore. So it's not going to affect anything in the nearshore area or anything that is above this aquiclude. So I think it can be developed without adverse impacts.
Yeah, understood. That's what your testimony. I just want to confirm all those. The second one, the next question is, would there be any problem or issue that would prevent the drilling of this well? Do you think any problem issue can come out to prevent drilling this well and in return not enough water for this project? I just want to kind of try to figure out what would stop the supply of this water to the project.
Well, I'm pretty sure that when we, which was not the case when the original application went in 2005 or 2006, but times have changed. I would expect, given its location, that during the pump testing, we would, as a condition of approving the permit, have to prove that we are not impacting the spring and the surface water nearby. So I'm pretty sure, or would be confident, that in approving the permit to drill the well, the conditions applied would include that kind of monitoring to demonstrate that the impact to the surface water and even the shallow groundwater is negligible. And we could do that in the well design, because in the annular space, we can put sounding tubes that can measure impact in the strata above the zone that we're pumping from. And we put water level recorders in there to demonstrate that when we get a drawdown in this lower formation, the upper water levels have no impact, no effect. So we do that plus any kind of surface water monitoring to demonstrate that.
You don't really see any.
Hold on.
We can pump from depth without impacting the groundwater and or the surface water above.
Yeah, I just want to kind of make sure that you don't see any really problem later on, whether it's government regulations or environmental thing, that would be a problem in supplying this water. You don't have to answer that. I just want to kind of confirm your testimonies, because I just want to kind of make sure I catch everything that, you mentioned that, drilling a well might cost maybe $500,000.
Well, to drill case and do the final pump testing and including all of the required monitoring and so forth, it's a very round number because I haven't made any specific estimate, but it's in that range.
Okay. Do you think that the cost would be is kind of cost prohibited for the project to move on?
I can't answer that. I have no idea about the finances of the project itself.
Okay. Thank you, Mr. Nance. Thank you, Mr. Chair. That's all I want.
Thank you. Commissioner Ohigashi, and then we might be running up against the need to take a break.
I just had a couple questions. First, referring you back to Exhibit 97 that was placed from Ms. Zaki, interveners exhibit. Is that your notes?
No.
Do you know whose notes they are?
I'm pretty sure, can't say for sure, but I'm pretty sure that it's Marcus Franson, who was the driller, the well driller. So
I just wanted to know because I didn't know whose notes those were. The other question that I have is regarding impacts to other wells or impacts downstream. Is it your position is that that really cannot be measured until the well is drilled and the tests are conducted at that time?
Yes, yeah.
And is that, is there any tests that can be done prior to the drilling that would indicate any of these impacts that may occur or may not occur, or rule out these impacts?
There wouldn't be any that I'm aware of. You'd have to get the perturbation of pump testing to create any impacts that might occur, just to see if you can monitor to pick up any impacts.
Yeah, that's all I wanted to know. Thank you.
Okay.
Okay, it's 11:28. We've been going an hour and 13 minutes, which is longer than I typically like to go. I had suggested we take a break for lunch right now till 12:15. This is going to disadvantage Commissioner Giovanni, who needs to leave our meeting between 12 and approximately 2 o'clock. So we could do one of two things. We could take a very brief break right now and then continue on till noon, take a break, and then from noon to 1, in which case I'll only miss an hour, or we could go as planned. Is there a preference among the commissioners? Commissioner Axon?
Can we go till noon? Then break?
Okay, so I do need to give people at least a chance to go to the restroom. So it's 11:29. We'll break just for 6 minutes till 11:35. Then we'll come back, go till noon. Then we'll take a break from noon to 1.
Thank you, Chair.
Thank you, Mr. Chair.
So,
It looks pretty easy if you just to download. I just downloaded it now.
oh, there we go.
It's just that under the video icon, if you press the arrow up and choose virtual background, and then it should be right there when it comes up.
But over the course of a 14-month pandemic, I've carefully curated my background and do not wish to blur it. So it's 11:35. Are we all back? Commissioners Okuda, Giovanni, Axon, Chang, Deputy AG Chow, interveners, Mr. Yu and Nancy Cabral is here. Okay, we're back on the record. Commissioners, continued cross-examination by the commissioners of Mr. Nance. Further questions from the commissioners? If not,
Chair, I don't believe Mr. Ewan is back and.
oh,
He's here now.
Oh, all right.
Thank you, Ms. Ahu. Any questions for Mr. Nance from the other commissioners? If not, I was starting to say before Commissioner Axon asked these questions, Tom, forgive me if some of these questions might appear to be repetitive, but I think similar questions have been asked you in slightly different ways by various parties and by the commissioners. I want to make sure I understand what the responses are. Can I start out with the UIC line discussion? UIC stands for the Underground Injection Control Line. And can you just help us understand what the purpose of that line is by the Department of Health?
The purpose of that is to indicate areas on the Mackay side of the line were considered at the point in time the line was drawn to be not potential sources for drinking water. And so disposal wells were allowed Mackay of the line in the assumption that it wasn't going to be impacting a potential potable water source. On the Mauka side of the line, the presumption was groundwater there was a potential source of drinking water supply into which disposal wells were not allowed to be drilled.
Okay. Can you tell me how large an area the Department of Health requires to be for neighboring property owners to be notified of a potential drinking water source if there is a proposed drinking water source Mackay of the UIC line?
I'd have to look that up. I'm not sure. It's either I think it's a 1/4 mile radius, but I'm not positive about that.
And is this, would you know if this is the way is it a Department of Health rule or is it a procedure that allows for this certification?
It's not a rule. It's a procedure that they created. I actually had drilled and got certified maybe 4 or 5 wells in the Kahului Aquifer that were Mackay of the UIC line that I hadn't picked up and that the Department of Health had not picked up. And then when I went to get 2 more wells certified for drinking water use, I said, my goodness, it's Mackay of the line, and I've got all these other wells already certified Mackay of the line. So I talked to Safe Drinking Water Branch, and they created these guidelines for wells that are on the potential drinking water wells on the Mackay side of the line.
Okay. So we're trying to protect drinking water sources from contamination as the basis of it.
That's the basic intent.
Yeah. And it ultimately relates to the Safe Drinking Water Act on federal law. Is that correct?
Could you try repeating that? I didn't get it all.
The purpose of drawing the UIC line is part of the state's compliance with the Safe Drinking Water Act, the Federal Safe Drinking Water Act.
I assume, but I'm not absolutely positive about that.
Is the if you're locating a potential drinking water source Mackay of the UIC line, do landowners does it only restrict their activities going forward, or would they also be required to remove any potential sources of contamination to the drinking water source for that water source to be allowed as a drinking water source?
Yeah, the pre-existing either disposal wells or individual wastewater disposal systems, they would be grandfathered in. They wouldn't have to be removed, and it would be up to us to prove to the Department of Health that those pre-existing potential sources of contamination will not be an issue for the drinking water well.
Thank you. Is there anything in your work in the record that indicates how many potential existing contamination sources there are within the area that the Department of Health would require notification on?
I think there's little or none at the moment.
In the record, there's little or none, just to clarify your answer.
A quarter-mile radius within where the new well would go. They're not in terms of man-made things or stuff. I'm not aware of any potential source of contamination.
So just to be really, I want your answer to my question to be really clearly responsive to my question. In the record or in your research, was there work done to identify any of these potential sources? Do we have documentation in the record that a survey was done to see whether there's potential contaminating sources existing within this area?
No such survey was conducted.
Thank you. Now I want to go to the other permit or the variance that you mentioned regarding the constructing the well below a recommended depth and seeking a variance to the well construction and pump installation permit standards from the Water Commission. Can you explain for those of us who don't know why there's an existing limit that you would have to exceed? Why the well construction pump installation standards have those limits in them?
Let's say what the limit is. The limit is that without prior approval from the commission with a variance, that you can't drill more than 1/4 of the thickness of what is assumed to be a basal groundwater condition. And if it's actually basal groundwater with saline groundwater beneath it, if you drill too deep and you pump at a rate that creates uptoning of the salt water into the freshwater zone, you have a problem with increasing salinity going forward. Not only a problem for the well, but a problem for the aquifer. And a very large percentage of all the wells in the state are basal groundwater, which that's an applicable kind of limit to apply. But in areas where you've got lava layers at and below sea level that are essentially impermeable, on West Hawaii, for example, we have in Kaupalehu area, we have to exceed the quarter lens thickness to get any yield at all. And in that case, we have to demonstrate to the Water Commission that we can not have this salinity issue drilling to that depth. On Kauai, it's a very different situation for the Kaua volcanics, or even the Waimea volcanics overlain by the Kaua volcanics, because we can put wells far closer to the shoreline on Kauai because of the Kaua than basically anywhere else in the state without running into a salinity problem. So a very large percentage of the wells drilled into the Kaua volcanics, because of its permeability layering, have to exceed what is assumed to be a basal groundwater condition. But it's very questionable that that actually is an accurate description of the groundwater that's existing in that formation. So we are basically required to stick to a depth based on the assumption of a free basal groundwater with saltwater beneath it, even though in this particular case and in numerous others that we've done on Kauai, if we stuck to the quarter lens thickness, we'd have no yield at all. So,
Thank you. Thank you. That's a very good description of why those standards are there and how you believe they might not apply here. I want to go from that to something that was mentioned by the interveners council in questioning. There appears to be a disagreement between you and Water Commission staff over the presence of an aquaclude in this area. Do I understand that correctly?
Yeah.
Can you explain that difference of opinion from your perspective?
Well, as I say, we just went through this virtually identical argument with the Water Commission on a well that was recently completed in Molowa, a little bit north of the area that we're talking about now. And they look at what the driller presents, and it's a layering that has layers of poorly permeable volcanics and clay and so forth. And so the driller's report says, oh, I encountered this water at this depth and this water at this depth. And they're assuming that this basically has, in the vertical thing, a hydraulic connection. We went through the exercise on the Molowa, this is within the last year actually, to demonstrate that that wasn't the case. And it's pretty similar argument that if we go through that same thing with a new well, we'd have to establish that for them. The realities are that what you're dealing with in the Kaua volcanics is very heterogeneous, very difficult to predict, varies from one location. But generally speaking, when you get a series of poorly permeable volcanics, clay layers, poorly permeable volcanic clay layers, which is the case, basically in total, it functions as an aquaclude.
So why did the Water Commission staff disagree with you?
You'd have to ask them, but the realities are they're not privy to, they're limited by what the well completion report says versus my experience in the field drilling wells and running into these small little perch water bodies.
Understood.
Separated, and they just didn't have that. And so that's kind of why we went through this long argument on the Molowa 1 well within the last year, and they finally agreed with us.
Okay, and who, is it the staff or the Water Commission that needs to approve these variances?
Well, it's the staff. In the case of the Molowa 1 well, it's Roy Hardy, Patrick Casey, Bob Schmidt, those guys on the staff.
Okay, so just again, since we're limited to the record, what we have right now, based on the oral testimony and the written record, is that the Water Commission staff believes there is not an anti-aquaclude. You believe there is, and that it's the Water Commission staff that has to be convinced, in part, that there's an aquaclude in order to grant the variance that's needed.
Well, no, the aquaclude isn't needed because it's basically the variance is to drill deeper. So, but let's say that they refer back to the original assumption of not an aquaclude. We can easily demonstrate to them that it is, because we can install the solid casing to a depth, louvered casing below that. But in the annular space, we can put multiple sounding tubes to various depths in what I'm referring to as the aquaclude, pump the well, and demonstrate that the water, the small little perch water bodies in the aquaclude have no response to pumping the well. I can prove that at that point in time with the annular space sounding tubes at varying depths.
So you would use, sorry. Go ahead. Sorry to interrupt you, Tom. Please continue.
Is there a question? I didn't hear you.
Oh, I think I interrupted the conclusion of your statement.
I think I said it all. I mean, if the Water Commission makes it an issue in approving the permit, we'd be prepared to say, here's how I'm going to prove to you with these annular space sounding tubes that it is in fact functioning as an aquaclude.
Thank you. My third set, and I hopefully won't take too long on this, just to summarize some of the testimony that you've given. If the well is dedicated to the Department of Water Supply, they may require an unknown percentage of the well to be dedicated to their use.
I would assume so.
Yeah, that is standard practice in Hawaii.
Generally speaking, for municipal departments of water supply, yes.
Yeah. So if the well with its proposed 500 gallon per minute capacity is dedicated to the county, there may not be sufficient production from the well to satisfy this development. Is that correct?
That would be correct if we install the 500 GPM pump. That's not necessarily the limit of the capacity of the well. The test rate of 530 GPM for the existing well was just, that was the capacity of the contractor's pump. So we couldn't pump more in that instance. But I would have to know before we even apply for the permit, if it's going to be for ultimate dedication to the Kauai Department of Water, what percentage do they need? Therefore, what capacity are we shooting for the well? And we'd have to go out and then prove that in fact we can produce that capacity.
But I've been relying on the statements from Mr. Bao that's attributed to you, the statement that you believed a 500 gallon per minute pump was could be used without and produce water.
The 500 GPM would work for a private water system. I'm assuming that based on negotiations between the parties, some portion of the well's capacity would be for Department of Water's use. And we'd need to know what that was so that we would have to know what capacity we needed to be shooting for in the well.
We have no evidence on the record right now that a larger pump capacity well would necessarily be that the aquifer that you're targeting would necessarily be capable of producing water for a larger pump.
We don't have any physical evidence on the record. It's my belief that we can do that, but we'd have
just
to
on the record that we have.
the well and pump it.
And of the brief pump test that you did, it didn't assess that, correct?
Yeah, I mean, we pumped it at up to 530 gallons a minute for 10.5 hours at that rate.
That's what I thought. Thank you. Last questions. I'm sorry, I know I should know this from the record, but I can't find it immediately. When was the well that will be abandoned drilled?
I didn't get the last part. The well that will be
the well
abandoned?
that the well that you tested, but that needs to be abandoned. When was that drilled?
I still couldn't hear the last part of your question. Sorry.
Sorry. The well which you tested, which needs to be abandoned. When was that drilled?
In 2006.
2006. Okay. But the landowner, or I understood from the testimony that it is not a well that was ever authorized by the Water Commission.
Well, I think they did get a well construction permit.
Okay.
And then they filed the well completion report, I believe, and that's where the response from the Water Commission emanated from.
That indicated that the well needed to be plugged and abandoned?
Yeah.
Okay.
That's a right call on their part, for sure.
Okay. And is there a timeline that's required on that plugging and abandonment under the law? Do you know?
I don't know. I'm sure that 15 years is longer than that would be. So, because I haven't been plugged yet.
So did this notification, just to your knowledge, occur during the time in which Mr. Peter Young was a consultant for the earlier version of the proposed project?
I don't know. I was aware that Peter Young got involved at some point after I stopped, but I can't recall.
But it is true that this is the same Peter Young who was once the chair of the Water Commission, correct?
Yes.
Okay. That's it for me. That's all I had. Is there anything further, commissioners? Otherwise, it's any redirect by Mr. Ewan.
Oh, Chair.
Oh, Commissioner Wong.
Just one question. Just can you define what aquaclude is?
An aquaclude is a layer of formation that hydrologically separates groundwater above it from the groundwater below it, so that you get two distinct and separate groundwater bodies above and below the aquiclude.
Okay, thank you. That's all I needed to know because I didn't know what aquiclude mean. Thank you, everyone.
Commissioner Giovanni.
Thank you. Mr. Nance, what's the ballpark cost to plug in this well that should be plugged by now?
It's probably between 15 and 20,000.
Thank you.
Anything further, commissioners? If not, any redirect, Mr. Ewan?
Yes, Mr. Nance, you were asked whether your report that was part of the environmental impact statement was complete or not. And I wanted to direct your attention to a portion of Petitioners Exhibit 4, Volume 2A. There's an Exhibit E in the report, I believe, and I'm referring to a memo that is included in the EIS that you drafted dated September 10th, 2012. Can you take a look at that, please?
Yes.
In that report, and you subsequently prepared a report that we've marked as exhibit number 22, which is your analysis prepared earlier this year, correct?
Yes.
Did your basic conclusion that the water source would be sufficient for this development, did you make that conclusion in your 2012 report?
Yes.
And you made essentially the same conclusion this year, correct?
Yes.
And what's the difference? Did you do further work and refine your conclusion?
No, not really. The memo that you're referring to, the 2012, was sizing criteria for what was going to be a private water system with this new well to be developed properly as a source of supply. And that's the same conclusion I've come to in my February 2021 memo.
Thank you. No further questions.
Okay, any recross? Connie?
Chair, no, Chair, thank you.
Ms. Kato, OP.
No, thank you.
Intervener.
Just a clarifying question. When you say your conclusion hasn't changed, you're speaking about this project. Your conclusion that there's enough supply for 769 units plus the commercial and everything, that still applies. Is that what you're saying?
Yes.
Okay, just clarifying. Thank you.
Okay, with that, we have made it through yet another witness in this proceeding. Thank you, Mr. Nance. I think you got off easiest, actually, of anybody who's appeared so far. It is 11:57. We will reconvene at 1 p.m.
Okay.
I'm glad to have not waited after lunch for
Thank you very much, Tom.
Okay. Thanks, Tom.
We can hear you.
Okay, thank you.
May her memory be exalted.
I know. Going up there with Betsy was like.
Betsy Gagne was a gem.
Yeah, I mean, the thing about her is she could mix both the biological and the cultural significance of the plants and, then historical significance all into one kind of grand tour of the place.
One of my favorite Betsyisms is it's the ecosystem, not the ego system.
That sounds like Betsy.
Okay, it is 12:59. I see Mr. Agar.
Here, this is Giovanni. I've returned early, so I'm on record.
Thank you very much. Welcome back,
Oh, that's
Commissioner
great.
Giovanni. That is excellent. We have Commissioners Okuda, Axon, Chang, Wong, and Cabral, Ohigashi, Giovanni, and myself. So we have a full slate. Ms. McManus, you're with us?
Yes, I am. Thanks.
Yay. Okay. Anything to stop us from going ahead, Dan Ordenker?
Nothing preventing us from going ahead.
Okay. And yeah, we have interveners and county and OP. OP? Yes, we do. I see you. Okay, it's 1 o'clock. We're back on the record. And petitioner's final listed witness, Ron Agor. Do you swear or affirm the testimony you're about to give is the truth?
I do.
Thank you. Please proceed, Mr. Ewan or Ms. Ahu?
I think Ms. Ahu would like to share her screen.
Okay, please go ahead.
Yes, sorry. My PowerPoint is pulling up. It's just a little bit slow, but I think it's good right now.
Mr. Agor, will you please state your name and address for the record?
Good afternoon, Commissioners. For the record, my name is Ron Agor, and I reside in Lihue, Kauai, 3728 Nawaluli Road. I was raised in Kikaha in a plantation environment since I was an infant.
What is your business affiliation?
I first started my career in San Luis, not San Luis Obispo, but in San Luis Obispo County in 1982 after leaving University of San Luis Obispo, where I studied architecture and some planning. And my first encounter in development planning was to work with a civil engineer who was commissioned to do 4 senior housing projects in the San Joaquin Valley. And my primary function was to do the site planning and drive out 2.5 hours to the San Joaquin Valley and meet with government agencies and continually keep in contact with them to make sure that we were on the right track. I even worked with the Corps of Engineers because 2 of the projects were near wetland areas. I practiced there for 4 years, and in 1986, I decided to return home to my home island, Kauai. And since 1986, I have been practicing architecture, engineering, development planning, land use, and environmental assessment work for projects in Kauai. And so my total years is about 35, 40 years of experience. One of my first encounters in development planning on Kauai was working with Robert Fox of Fox, Hawaii in master planning the Waimea Plantation cottages on the west side. And throughout the 35 years, I have done a lot of pro bono work for most of the major nonprofit organizations and helping them plan and get use permits and environmental assessments on a pro bono basis for their projects. And I mentioned that because working with these nonprofit organizations have helped me immensely in my development planning work. I learned so much from them in terms of the pulse of the community, the problems that develop, and they miraculously always come up with solutions to help people. And in all of my projects in planning and in architecture, I try to do everything I can to implement what I learned from these nonprofit organizations. So to bring me up to current situations. I have just completed the draft master plan for 155-acre parcel for Kitiolo Land Company in Waimea, Kauai. And the master plan was focused on the best use of the property according to the needs of the community and according to the newly developed general plan. Also recently, we completed the development planning and design for a 100-unit cottage-style housing project in Kaua called Kaua Southtown. Across the street from Kaua Southtown, we completed the planning and design, use permit work for Kaua Estates, which involved some single-family dwellings and a 72-unit condominium project. So that really sums up my background as a development planner and architect.
Okay, Mr. Agor, is the HoKua Place property appropriate for this development? I certainly believe so. HoKua Place is a large undeveloped parcel close to Kapa'a town. HoKua Place is reasonably close to government services. The project will provide housing close to where people work and should alleviate traffic coming from the north. Despite being classified as agricultural land, HoKua property is subject to trade winds, lack of irrigation water, and inappropriate for intensive cultivation given the proximity of Kapa'a Middle School. The county does not propose to include HoKua Place in its designation of IAL lands. Please describe how HoKua Place complies with the Kauai County General Plan.
The Kauai General Plan now designates HoKua land in the category of neighborhood general zoning. Neighborhood general zoning applies to properties or developments that are within the 10-foot radius of walking distance. And the purpose of that is to, one, minimize traffic and to integrate residential developments with the town. HoKua Place would accommodate residential growth in central Kapa'a, and it complies with the goals and objectives and policies set forth in the Kauai General Plan.
Given the concern expressed by some testimony regarding the location of new housing closer to employment center of Lihui, do you believe that the HoKua Place project site is an appropriate location for a large new housing project in East Kauai?
I think it is appropriate location for a housing project to address the housing needs of Wailua and Kapa'a area. Now, I belong to the APA, and I hear chatter on the internet for the last 10 years about shifting housing to where the workplace are. My belief is that sometimes planners and even architects like to come up with one solution for all and try to push their idealistic ideas into play. And sometimes we don't look at the needs and the wants of the people that we're trying to help. Now, the idea of putting housing where the workplace is works really, really well in metropolitan areas. You take Los Angeles, for example. You can drive miles and miles, and compared to Wailua and Kapaa, you drive miles and miles and you see the same ugliness, okay? So it doesn't matter where the people live. In fact, it's a bonus if their homes are being placed where their workplace is, yeah. But Kauai is different. The Kapaa and Wailua area is different. Mr. Cassidy has pointed out that there are many families that are doubling up with their siblings, many families doubling up with their parents. And they choose to live in Kapaa for a reason. Yeah, their wants and needs are that they grew up in that area. They went to the elementary school. They went to the intermediate school and the high school. They played in Kapaa town. They went to the beach, and now an element of having the bike path there is a big draw for people to want to continually live where they grew up. And besides that, anything Mauka of the bypass road on up, and even in the Wailua homesteads, it's an unbelievable place to live. It's a beautiful place to live, and they've got ocean views, coastal views, majestic views. They got views of the mountains with trees, and they want to live there. And who are we to say that if you want housing, you got to move to Lihue? They don't want to move to Lihue. They don't want to go there and live and listen to the airplanes fly till 11:30 at night. So we have to treat people and communities individually and not use a cookie box cutter solution. So I think it's appropriate to have this housing project in Kapaa. The general plan states, the old and the new general plan stated that we need to address housing in Wailua and Kapaa. It didn't say we need to address housing for Wailua and Kapaa by moving the population to Lihue. So I think we need to treat Kapaa and Wailua residents who are looking to buy their first home differently from that cookie box cutter solution.
Turning to the next area of questioning, are you aware of any wetlands on the HoKua Place property? And if so, how does the petitioner intend to develop this area?
Okay. I've had extensive experience with Fish and Wildlife, Corps of Engineers, USDA. And I know that the entity that's responsible for delineating wetlands in our communities is the USDA, U.S. Department of Agriculture, along with their sub-agencies, the NC, the NRCS, and the National Wetland Team. These people would go to communities, and they had the tools and the scientific knowledge to be able to demark where wetlands should be. And once they demark wetlands in a community, it's then turned over to the Corps of Engineers jurisdiction for enforcement, for entertaining permits to work with any wishes wetlands. And the draft EIS produced by my predecessor spoke about a 0.3 acre of wetlands that are on the property, but not necessarily within the boundaries of the petition area. And it depended on a map that's on page 16 on volume 2C, I believe, generated by the USDA. And keep in mind, the USDA is the entity that delineates wetlands in communities. And that map, dated May 5th, 2018, the 3.8 acres that suddenly appeared to be wetlands was not on that map. Okay, and since OP brought up the findings, I went on site and searched for U.S. Fish and Wildlife's map. And the only map I could find was a map developed in 2019 that shows the 3.3 acres. Okay, so I believe, I strongly believe that Fish and Wildlife acted on developing their own map. And going back historically, once the wetlands are delineated in a community, U.S. Fish and Wildlife, whose objective is to protect fish and wildlife, have a tendency to develop their own map and expand the wetlands and give it a certain category, a certain type of wetland, and it's identified on their maps. So I have
One moment, Mr. Collins.
Mr. Chair, we have an objection to this testimony. Is a party permitted to have its own witnesses impeach its previous witnesses?
To the degree that that is the case, which I'm not saying it is, it certainly wouldn't be in the interest of the petitioner, but I wouldn't see why that we would bar petitioner from having their witness state what they wanted their different witnesses to state. So I'm not understanding the nature of your objection, Mr. Collins.
Oh, sorry, I thought it was like it related to the efficiency of the proceedings, but if I'm sorry, if that's not the custom here, then I'll withdraw the objection.
I mean, it is, if that is the case, that would be unusual.
Okay, sorry, I'll withdraw then. Thank you, sorry.
Thank you. Please continue, Mr. Ewan, with Mr. Agar.
So my feeling is that when we sent out the draft EIS to all of the agencies, including Fish and Wildlife, it was then that Fish and Wildlife decided to address the area. And it was then that they developed their own map and labeled a 3.3 acre part of HoKua lands as wetlands. And so here's the fun part, okay? And I'm gonna ramble on, but it's important. Fish and Wildlife, and I'm okay with them developing their own map because they have a mission to protect fish and wildlife, so that's okay. They categorized that 3.3 acres as a certain type of wetland. And the nomenclature for this 3.3 acre wetland is PSS 3C.
letter and number has characteristics of a land that qualifies it for this type of wetland. Okay? P stands for polystyrene environment, where the property is less than 20 acres. And yes, this property is 3.8 acres, so it qualifies. The next characteristic.
Mr. Agor, could you double check, is it 3.8 or 3.3 acres?
I'm sorry, 3.3 acres. Sorry. And then the next category is having lands where there's water that's less than 2.5 meters. And there's no chance of this 3.8 acres having a body of water. The land slopes a minimum of 15% in one area, but for the most part, it's 30 to 40%. But there's no way water can accumulate a pond-like situation there. So it doesn't qualify in that sense. And another aspect of P is salinity in the body of water. There's body of water, there's no salinity. And then the last item is having a strata of earth similar to that of the coastline. And this property is predominantly silty clay and a mixture of silty sandy clay.
Mr. Agor, did you physically inspect this area?
Yeah, I'll get into that.
I'd like to, before you go further, I'd like to have a slide put up, Exhibit 37, which has been admitted into evidence.
Go ahead. I will say, Mr. Yuan, while I'm not commenting on Mr. Collins' objection that he withdrew, but it'd be good to keep these proceedings as efficient as possible. It's going a bit slow.
Jana, can you put up?
Give me 1 second, it is just loading. Mr. Chair, can I share my screen, please?
Please go ahead.
Mr. Agor, did you take this photograph?
Yes, I did. I took it in the morning after heavy rain for a couple of days and nights in the area.
And is this in the 3.3 acre area that has been classified as a wetland?
Yes. This is on the western boundary of this 3.3 acres. And really what you see in front of you is a old Cane Hall Road. And you can see, I mean, the condition of the land there is free of any flooding or any saturated land. And if you look to the right, you see the slope of the land towards the bulk of HoKua property, and it ranges from 50 to 40% slope. And on the right side is where we have growth of java plants, and it's only java plants that going over there, except for a few weeds. And to the left, there's a lot of hawbush.
So are there any native species there?
No, they're invasive species.
And so what is the petitioner's plan for this area?
This area has always been in the green zone of the site planning. There were absolutely no intentions of going vertical in this area at all.
Notwithstanding its designation as a wetland, is it appropriate to include this 3.3 acre area in the land to be reclassified to the urban district?
I need it to be included in the petition area. When we start our planning during the county level, if we end up with a density of or 10, that's 10 units per acre, 3.3 acres converts into 33 units. And then it converts into 9 affordable housing units. And I cannot lose 30 units.
From a regulatory perspective, Mr. Agor, is it appropriate to reclassify the land into the urban district? From the perspective of zoning controls and other regulations?
Yes, it's appropriate to have it be part of the boundary amendment.
Okay. Next, can you please describe the work of your botanical consultants, Kenneth Wood and Megan Kirkpatrick, your biological consultant, Reginald David, and your invertebrate consultant, Stephen Montgomery?
Well, both studies found that there were no
Who is shuffling papers?
I believe that was the witness. Here, go ahead.
no endangered or threatened species of plant, bird, mammals were found on the property, and no endangered invertebrates were found on the property.
What measures will HoKua Place implement to minimize noise pollution?
The increase in traffic-related noise to HoKua Place is not considered significant. HoKua Place operations are not expected to cause a significant noise impact. No mitigation measures beyond the compliance with applicable regulations and standards is required. Contractors must consult with DOH per Title 11, Chapter 46, on community noise control. If construction noise levels are expected at any time to exceed DOH maximum permissible property line noise levels. Walls, fences, landscaping, and other sound measures can be incorporated into project plans to help buffer the project from impacts of vehicular traffic noise, as well as minimize impact of noise from the project on nearby residents.
Next, Mr. Agor, turning to air quality, what measures will HoKua Place implement to minimize adverse impacts to air quality?
Some short-term impact air qualities during construction can be expected from fugitive dust. Mitigating measures include watering and installation of construction screens. Following construction, any change in air quality during HoKua Place expected to be well within the federal and state ambient air quality standards. HoKua Place will participate in any air quality monitoring programs required by DOH.
Could you please discuss the availability of government services and utility services to HoKua Place?
The Kauai Police Department provides police protection for Kapa'a area from substations in Kapa'a town, approximately half a mile away from the property. The fire department provides fire protection for Kapa'a area from a new county fire station at the north end of Kapa'a town, approximately 2 miles from the property. My Halona Hospital.
One moment, Mr. Collins.
I'm very sorry. It sounds like somebody is dragging something somewhere, and I'm having very difficult time hearing the witness at certain points. Is it possible whoever is dragging something near a microphone, if they could stop doing that, or could I ask the chair to ask for whoever's doing that to stop doing that.
I think it might be coming from Mr. Ewan's office.
I just moved the witness's microphone. I think that might solve the problem.
Okay, and then just if we could, we all can read the PowerPoint, so let's, take the great advantage of the expertise of the witness being with us to the direct testimony, please.
Can I continue?
I'll go to the next question. Are public school facilities available to HoKua Place?
Yes. Kaua Elementary School and Kaua Middle School have capacities beyond the proposed or projected enrollment. The Kaua High School capacity is less than what's expected in enrollment in the area. HoKua Place is not a designated school impact fee district, so no contributions are required.
Could you please describe HoKua Place's compliance with the Hawaii State Plan and the state functional plans?
Yeah, HoKua Place complies with many goals and objectives and policies set forth by the state plan and the state functional plans, particularly plans for affordable housing, social, cultural advancement, employment, population growth, transportation, and recreation.
Have you had any conversations with the County Housing Agency regarding compliance with affordable housing requirements and continued enforcement of affordable housing guidelines?
I've had discussions with the county housing agency, and we just briefly spoke about the housing project. We didn't really get into that, but I've had extensive discussions with the founders of the affordable housing law. And at this time, I'd like to address issues that came up yesterday with regards to the idea that affordable housing on this project should be capped in perpetuity. Okay. The project intends to provide 233 affordable units. The founders of the housing law knew that it wasn't reasonable to put limits on the equity or when people who buy affordable homes in private developments be restricted. I have to say this. I believe in the American way, and I believe in life, liberty, and pursuit of happiness. And having young families buy their first home and use their equity at their discretion to advance themselves in our community for better life is a huge part of life, a huge part of the pursuit of happiness. I believe when government restricts the use of land, say, put a 10-year time limit, all they're doing is keeping the poor poor. And I would like to see that we help 231 families to advance with their equity at their discretion. And if we all feel that we need more affordable housing, then we'll go through the process of approving another project with another 231 units. And anyway, that's my belief in
trying to restrict affordable unit buyers in exercising their right.
Could you next turn to describe the compliance of this project with coastal zone management criteria?
HoKua Place is 1/2 mile inland from the shoreline. HoKua Place will mitigate storm and surface water runoff concerns by retaining excess storm waters on site detention basins. No known historic sites, burial sites, or customary and traditional Native Hawaiian subsistence, cultural or religious practices exercised on the property. It satisfies the Pa'akai and Okai Aina test. Now, I heard comments last night about just because our archaeologists did not find any historic sites, it doesn't mean that they may not exist, or just because we didn't find traditional Native Hawaiian practices, that too doesn't come into play. And I sat on a state land board for 8 years prior to the current member. And I know that there are sometimes on projects inadvertent findings of historic sites and burial sites. And there's a mechanism to take care of that, okay? If you find something, you rope it off, you call Shipta, and they deal with it, and you continue on construction. And as far as the traditional Native Hawaiian practice exercise on property, I've always emphasized to property owners that one day someone may approach you and say that my grandfather had accessed this property and I would like to do the same and do the same practice as him. And if that happens, you must listen to them and accommodate them. And I know that the developers of HoKua property will honor that situation.
Could you,
Sorry, Mr. Ewan, how much longer?
I have about, probably about 10 minutes.
Okay.
Could you please I'm sorry. You've heard testimony that no one has discussed the HoKua Place project with them, or other people have said nobody has solicited their input on this project. Can you please describe your personal community outreach efforts and community meetings you have attended where the HoKua Place project has been discussed?
This is a really important subject, because every project should engage in as much community contact as possible. I was disappointed to hear that the Sierra Club member that spoke said that we never contacted them or never discussed HoKua with them. And the evidence shows in the draft EIS and the final EIS that the documents were sent to them. They made comments. We responded to the comments. And I even personally delivered the final draft EIS and the final EIS to one of the board members at the Kapa Library. We have done a lot of outreach for this community, on this project. We presented the project to the Kauai Business Association, presented the project to the Rotary Club. We had a conference on the general plan update, and at that conference, we managed to have a separate meeting to present HoKua project to the residents of Kauai and Wailua, should they choose to attend. And we had a pretty good meeting. We had a pretty good dialogue. We also testified in front of the Planning Commission and the County Council twice in a public setting, televised for everybody to see. And we talked about the HoKua lands on those meetings. And I personally, on all of my projects, I make contact with the community. And I walked around Kauai town and stopping people and introducing HoKua lands to them and got input from them. And Kauai is a small town, so it's easy to do that because you recognize everybody. So it's easy to approach them. I even put a little site plan on a cardboard and stood in front of Safeway and try to talk to people. So there were a lot of community outreach, and I don't want the commission to think that we never reached out to the community and informed them about the project, because we did.
Before I turn to the next, well, let me finish on this line of questioning. Could you describe HoKua Place's compliance to the urban district reclassification standards? Jana, the last, Jana? Oh, okay, here we go.
HoKua Place site is bordered by Kauai town. Lands either side of or planned for residential and other urban development and characterized by city-like concentration of people, structures, streets, and urban services, and related land use. The project implements policies of the 2018 Hawaii General Plan by developing lands designated neighborhood general.
Sorry, I need to interrupt. Mr. Collins?
Hi, yes, I'm sorry. We have an objection that we believe that reading this entire slide, which is much lengthier than the other slides, is definitely cumulative and an inefficient use of time.
I have tried to suggest to the petitioner, maybe too indirectly, that this is going very slowly. I don't want the petitioner at all to feel prejudiced in presenting their case, but I would observe, based on body language, I think the intention of my fellow commissioners may be lagging.
We'll waive the reading of the rest of the standards and assume that it is entered into evidence. I do have one other area that I want to examine Mr. Agor on, and that concerns Petitioners Exhibit 44. Together with 46, those two are the subject of a stipulation. They have not been entered into evidence yet, and at this time I'd like to move Exhibits 44 and 46 into evidence so that I can examine Mr. Agor regarding this exhibit.
And sorry, once again, 44 and 46 are...
46 is the contract with the developer and Randall Okoneku that the commission requested. And 44 is an estimate of development costs that
was requested by the commission. Yes. Thank you. Are there any objections from any of the parties to entering these into the record, starting with the county?
No objection by the county, Chair. Thank you.
Ms. Kato for the Office of Planning.
No objection, thank you.
Intervener.
Mr. Chair, we just want some clarity that Architect Agor is able to answer questions related to these exhibits on cross-examination.
Mr. Ewan? Is that
He
the
is,
expectation?
He's going to answer questions on 44, but not on 46. The only reason we're putting in 46 is one of the commissioners requested it.
Mr. Chair, could we ask that 46 be taken up after Architect Agore's testimony?
Yeah, if and when I think we choose to recall Mr. Bracken, perhaps would be the best time for 46. Mr. Ewan?
Okay, what about 44?
44 is the agreement with Mr. Okuneku?
No, 44 is the development cost estimate.
Okay, so that's, I think what we're saying is, let's leave up, and sorry, we only wanted, I'm suggesting we only try to admit the one that Mr. Agore is speaking to. Which one is that?
44.
Okay.
That's 44.
Okay. Is the petitioner okay with that? Just admitting 44 at this time?
Yes.
Mr. Axon, Commissioner Axon, you have your hand raised.
Thank you, Mr. Chair. Going back to the last PowerPoint, I just want to make sure that the witness, the petitioner, their points were properly conveyed on that PowerPoint. Perhaps not reading the PowerPoint, but point by point.
Hold on, sorry, Commissioner Axon, I thought you were speaking directly about the admission of evidence. So I will take that up in a second. No objections to admitting the one additional piece of evidence into the record. Is that correct? There was nothing from the county, nothing from the Office of Planning, Mr. Collins?
Yes, we don't have an objection to admitting at this time the exhibit that Architect Agore is able to speak to.
Commissioners, any objections? Seeing none, it's admitted. Taking up the concern of Mr. Axon, he just wants to ensure, which I've tried to also convey in my statements to the petitioner, we're not trying to, in any manner, restrict your ability to have your witness present information. We just want to maintain the efficiency of the proceedings. That's understood, Mr. Ewan?
Yes.
Okay. Please continue.
Okay, Mr. Agore, directing your attention to exhibit number 44, which is a summary of the projected development cost for HoKua Place. Can you please describe how you arrived at these cost estimates, starting with the estimates for construction costs?
Mr. Chair, can I share my screen?
I wish you would.
Look at it.
Let me know where you want to go, Bill.
I think, Ron, what page do you want to start on? That, I think.
Well, you know, I had lengthy discussions with Mr. Cassidy. He and I, and information that I gathered from current contractors in the area, came up with quantity square footage cost based on the projected size of the units, and that's how we came up with the vertical construction cost. And it speaks for itself. You know, we estimated just a little over $211 million for the vertical construction cost. And totally, the total projected development cost included the site infrastructure cost, which was developed by Kauai engineering, and then we added a 15% self-cost onto the total. So the total comes up to just under $400 million.
Under $400 million or under $340 million?
Oh, I'm sorry, $340 million.
For the commission, can you explain what you considered to be soft costs?
Any fees, loan fees, permit fees, land use.
And so the total development cost, including land, would be approximately $340 million?
Correct.
And because this project is going to be developed over a series of years, what do you estimate to be the potential amount of cost that the petitioner would be exposed to at any one time? Maximum.
Yeah, going with past history with some of the projects that we've done, the percentage I interjected was 25% of the development cost at any one time.
So what would that figure be?
$85 million.
Okay, I have no further questions for this witness.
Okay. Thank you. It's 1:51. Let's begin with the cross. County. Oh, Commissioner Ohigashi.
Before we go further, is it, I'm trying to look it up, so I have a copy of it. Do we have one in our, that has been provided to us? I'm just trying to find it in my exhibits. Exhibit 44. I'm just.
Yes. Mr. Hakoda, is it posted?
I don't believe it is, Mr. Chair. I don't recall receiving it.
This tip 44 and 46.
Yeah. Did you post?
We got it. We sent it to the parties.
Did we post it to the website?
I got to check now. I can't remember.
We're checking on that website posting. Just a moment, Mr. Chair.
Thank you.
We did submit it last week.
It wasn't admitted until about 2 minutes ago.
Yeah, right.
If it could be emailed to the commissioners and the parties, please. While we're waiting, Mr. Donahoe, how long do you think you have?
Chair, I probably have about 25 minutes to a half hour.
Oof. Okay.
I'll try to speak fast, but I don't want to underestimate.
Ms. Kato? What's your time estimate?
Sorry, maybe 20 minutes.
Ms. Isaki?
I'll be doing the cross-examination of this witness. I'm hoping 5 or 10, maybe less if the county and Office of Planning ask questions that are on our list.
Okay. Does anybody have a concern with us proceeding with the county's cross while the commission is emailing the newly admitted exhibit to the parties and commissioners? Is there any objection from anyone?
None.
County?
Thank you, Chair.
County, no, sorry, no objection?
No, I have no objection.
OP?
Thank you.
No objection. Thank you.
Interveners?
No objection. Thank you.
Commissioners? Okay. Please proceed, Mr. Donahoe. And we'll go at least like 10 minutes or so and then see where you're at and assess the need for a break.
Very well. Thank you, Chair. Hi, Mr. Agor. Thank you for being here. I just had a couple questions to start about your background. I noticed that you list so you're the main architectural firm that was responsible for the design of HoKua Place?
HoKua Place?
Yes.
Yeah, I mean, the project hasn't been designed yet. We're not going to go into design until the entitlement process with the county.
Okay.
All
But you're the
site plan.
Yes, but there are site plans, correct?
Yes,
And you were the designer of those.
yes.
Okay. And then you list several colleges that you attended. But I was just curious, what specific degrees do you have and in what fields?
My schooling was at Kauai San Luis Obispo in architecture and planning.
Okay. Architecture and planning. Okay. So on page 3 of your PowerPoint presentation, you stated that HoKua Place is subject to trade winds, lacks irrigation water, and is inappropriate for intensive cultivation, given the proximity to Kaua Middle School, correct?
Right.
Okay. So specifically, if your educational background is in architecture and planning, whose opinion did you rely on for that statement?
My consultants.
Okay.
that did the
So
estimate.
okay.
They
So you didn't conduct the study yourself?
No. I'm the manager of the final EIS, and my job is to pull together the studies from my consultants to put it together in a form to present to be published for your approval.
So the opinions that you've given on the traffic issues and on the traffic issue, that was based upon what you were told. That's it.
Exactly. Or what I read.
Okay. And then your presentation, you also made statements about the wetland area in the petition area, and you stated that you made a reference to discussions that you had with U.S. Fish and Wildlife, correct?
Not U.S. Fish and Wildlife. I met with the Wildlife Division NDAR of DLNR on site.
And then maybe I misunderstood your testimony, but you stated that the maps that the Fish and Wildlife had about this area, the wetland area, was not accurate?
The designation, the physical aspects of the 3.3 acres do not match the category designated wetland. It doesn't match. It appears somebody just drew the 3 acres and put the designation without going to the site. I mean, out of a dozen qualifications for the property to be that type of wetlands, the PSS3C, only one characteristic applies for the 3.3 acres, and that's land being less than 20 acres. All the other characteristics don't apply.
Let me stop you there. Let me ask you this. But you don't know what they did to make their map, correct? That's just your opinion that it's inaccurate.
Yeah, I said it was my opinion, sir.
Okay, thank you.
I was trying to figure out why the map suddenly appeared in 2019.
Okay. And again, the statements that you made about endangered, threatened species of plant life, birds, mammals, that was just based on studies, not that you did, but that's just the opinions that you were given.
Exactly.
So on page 5 of your PowerPoint, you touched upon it briefly, you state that HoKua Place complies with the goals, objectives, and policies set forth in the 2018 Kauai General Plan, correct?
Correct.
And you're familiar with the general plan?
Yes.
Okay. So in your analysis, did you specifically analyze each of the proposed vision and goals and policies to guide growth listed in the 2018 general plan in your analysis of HoKua Place?
Correct.
Okay. So specifically regarding the 4 visions and goals, is there any information that you contained for meeting goal number 1, a sustainable island? How the HoKua Place would lead to a sustainable island?
Yes, let me get on my notes.
Would that information be contained in the FEIS?
Yes, it would be.
Okay. And then is that your same answer for goals 2, 3, and 4?
What was the question again?
Are you, for goal number 2 in the general plan, a unique and beautiful place? Is it your testimony that evidence of that is your findings and conclusions and your opinions is contained in the FEIS?
No, I didn't mention that in the EIS. It was just, I mean, I know the area very well.
Okay.
Okay, the goal, there's 4 goals in the general plan. And I don't know if you want me to go through.
And did you include that information in your analysis in the EIS?
Okay. The vision set forth in the general plan has 4 goals. A sustainable island, a unique, beautiful place, a healthy and resilient people, an equitable place with opportunity for all.
Correct. And in your analysis of HoKua Place, did you submit your findings and conclusions or your opinions as to how the general plan for those 4 goals were met? Is that listed anywhere in the record, such as the FEIS? And where is that?
Pages 154 to 156.
Okay. And then are you also familiar with the 19 policies to guide growth?
Yes, they're within the pages I just gave you.
154 to 156?
Yes.
Okay. So I want to talk to you about a couple of the policies. So policy number 1 is to manage growth to preserve rural character. So how specifically does the 769 unit development preserve the rural character of Kauai?
HoKua Place is strategically placed, you're talking about policy 1, yeah?
Correct.
In a neighborhood general designation. It is substantially within a 10-minute walk to Kaua town. The project will include smart street designs, short residential block, walking and bicycle paths integrated with the Kaua town's future paths. The project is intended to help preserve the rural character of Kaua town. Therefore, conforms to policy 1.
Okay. So for policy 2, you testified about affordable housing. Now, the development is proposing 30% affordable units, correct?
Correct.
So that would leave 70% not affordable under that definition. 70% would not qualify as affordable. Okay.
Right. Correct.
No, thank you. You answered it.
I mean, not in terms of the lower income people, yeah.
Correct. In policy number 10, help business thrive. Is there any particular study that you did or that you can point to that shows that HoKua Place, development of HoKua Place will help business in the area thrive? What was the study that was done?
No study. It's only logical that when you have a housing project integrated with the town, the housing project will provide a workforce for the businesses in the area and vice versa. People who are looking for jobs can integrate with downtown and find jobs in downtown. It's as simple as that.
Okay. And is there any study other than, is there any study that demonstrates policy 6 that the HoKua place will specifically reduce the cost of living?
Policy 6 emphasizes to reduce cost of living. HoKua place will help reduce cost of living minimally by reducing the need for driving into Kauai town.
Okay.
With the increase in population created by this project in the area, more businesses will develop, thus creating jobs where residents can live and work without the use of motor transportation.
That's not based on any study. That's just a guess as to what's going to happen.
Yes, yes. And you got to understand that the general plan lays out what they want. And this just responds to how we're living up to the policy.
Okay. Thank you. Chair, I was going to switch to just talk about the design of HoKua Place if this was the time for a.
Yeah, so if we're at a breaking point, I am. So it is 2:06. Let's reconvene at 2:16. And I'm also going to ask for from the commissioners and the parties an estimate of how long we can go after we reconvene. Reconvene at 2:16.
Sorry.
Hey, it's 2:16. I need to assess from my fellow commissioners what time constraints they might have today. Commissioner Wong.
Yes, Chair, I have a 3:30, so I have to leave by 3.
Anybody else? I have a 4:30 via Zoom. Do any of the parties have a restriction to going to 4:30?
I do not.
Not from the county chair.
We are available. Thank you.
Okay. And just Mr. Wong. Okay. Yeah, we've spent a lot of time on this docket. Let's move ahead. Please continue, Mr. Donahoe.
Thank you, Chair. Permission to, I was going to go over the design, the conceptual site plan. Permission to share a screen?
Please.
Is it
Correct, site plan?
not?
Not the phasing site plan.
Sorry, it's not going. Let me stop the screen share. It's not going.
What would you like to share, Mr. Donahoe?
Page 15 of the FEIS.
Okay. Why don't you start your questioning, see whether or not that can be, I can pull that up.
Mr. Chair, if I can interrupt for a moment, I just want to
Yes.
note for the record that exhibits 44 and 46 are posted on the website.
Great.
They're part of the stipulation.
They're part of the stipulation that was sent to us, and as a result, that caused some confusion as to what is actually being posted.
Okay, thank you.
Okay, Mr. Agor, you're familiar with the conceptual site plan that you designed that's in the FEIS?
Correct.
Okay, it's dated March of 2015. To your knowledge, does this continue to represent the conceptual site plan layout of the proposed development as of March 2000, or as of today?
Yes.
Okay. So focusing on the entire proposed site plan that's on page 15 of the FEIS, the entire development area is separated into two phases, phase 1 and phase 2, correct?
Yes, yes.
Okay.
Phase 1 is the HoKua ag land, and phase 2 is the 97 acres.
Yeah, and in the 97 acres of phase 2 HoKua Place, that's the highlighted section, that's the subject of this reclassification petition, correct?
Correct, sir.
And the project is proposing segregated areas for multifamily units and single-family units, correct?
Yes, they're divided by Road A. But we do have multifamily next to the Kaua Middle School, to the right of Road A.
Okay. Would you agree that there's a market for mixed housing types instead of just clustered high-end developments?
In this project, what I intend to do when the entitlement process starts is to integrate affordable homes with the market homes. You know, in each building, I want to have an element of affordable homes in it, so that there's no stigma, so to speak, and people can socially get along.
Thank you, Chair.
This is the figure that you were looking for?
It is, thank you. And separating phase 1, the large ag lots, from HoKua Place phase 2, there's a single road going through the entire complex that would separate the ag lots from HoKua Place, correct?
Yes.
Okay. And then how you just testified about the multifamily, single family, the proposed site shows the multifamily units in the southern portion, and then just east of it would be the single family residences, correct?
Correct.
And then there'd be a green belt north of that, and then another single family residence, and then another green belt.
Yes.
Okay. And then the last section of multifamily units would be located right next to the Kaua Middle School.
Correct.
Okay. Where specifically, if you know, in the proposed site, would the location of the workforce or affordable housing units be?
I don't, you know, like I say, in the entitlement process, I'm not looking forward to.
Is the answer it's not located yet?
No, it's not located yet.
Is it, if you know the intent of the developer to integrate the multifamily units, the affordable housing units with the market rate units?
I've mentioned it to them.
Okay.
And one of the conditions you need to understand that I took on this project was basically I wanted 231 affordable units in there, and I had mentioned that I wanted to integrate that with the market housing. I don't want people to drive through the subdivision and say, oh wow, there's affordable units, and on the right, oh, there's a market unit. You know, I don't want the vision of separation there. So I'm hoping to integrate them.
Mr. Donahoe, do you still need this pulled up?
I have, no, that's it. Thank you, Chair. And have you discussed with the developer, and would it be your recommendation to possibly have a phased development that requires that a percentage of workforce housing be constructed on pace with the higher end development? For instance, like a schedule that a certain amount of workforce housing has to be done on par with the market rate units.
In terms of its location,
Yes.
yes, I've discussed it with them.
Okay. And and is that something the developer is open to?
Yes.
And then are you familiar with smart code or form-based code?
Say that again?
Are you familiar with form-based code?
I think if you describe it, then I would be able to say if I'm familiar with it. I'm not too familiar with that terminology.
Okay, it's a land development regulation that the true definition is fosters predictable build results by using physical forms of buildings to create a match in look and feel of a place to match the surrounding areas. Are you familiar with that process of form-based code?
Yes, as an architect, that's what we do.
Okay. How about, are you familiar with the process of, I believe smart code is referred to in the FEIS. What is smart code?
No, I'm not. I mean, again, if you describe it, then I can tell you if I'm familiar with that process or not. I'm not familiar with it.
Okay. So you don't know if something similar to form-based code would be applied to HoKua Place?
Yes.
Okay. Yes, it would be, or yes, you're not sure?
Yes, it will be.
It will be, okay. And then do you understand that should the State Land Use Commission grant the petition, the amended petition for the boundary amendment, the proposed development will still have to be reassessed at the county level? I think you testified you understood that.
Yes, I understand that.
Okay, and that the county may recommend a master plan to be required before a zoning amendment?
Absolutely.
Okay, would you agree that the master plan will increase the cost and timeline for the project?
Cost and timeline. I think in my proposal to the developers, that's already set.
Okay.
It's not going to increase from what we anticipate.
Okay. And as a result of the master planning process, do you understand that the county may require that form-based code may be included in a zoning amendment if that's what's recommended?
I'm well aware that process takes place in developments like this, yes.
Okay, perfect. Thank you. Thank you, Chair. Thank you, Commission. I have no further questions. Thank you, Mr. Ogor.
Thank you, Mr. Donahoe. Ms. Kato.
Hello, Mr. Agor. Initially, it was mentioned by the county, but there are a number of witness subject matters that are listed as that you're testifying on. So I just want to clarify, or could you clarify what your role and responsibility is for this project exactly?
Well, I was asked to continue the completion of the EIS as the manager for the EIS process. And I have been retained to be the planner, development planner, when the entitlement process with the county begins, where we actually really start the planning of the subdivision.
Are you generally responsible for overseeing all the consultants?
Yes.
Okay. So with respect to your responses on the location of the wetlands and the U.S. Fish and Wildlife designation of the wetlands, do you have any specific expertise regarding this matter?
Do you have any
expertise regarding the wetlands?
Expertise?
Mm-hmm.
Yeah. Well, as far as the designation of the wetlands of the 3.3 acre, I am now.
Okay, can you please describe your qualifications for that?
When we were notified of the discovery of 3.3 acre, I'm an educated architect, and I have experience in engineering, and it doesn't take a lot to do research and find out what the designation was and what the qualifications of the lands to qualify for that category of wetlands. I have diagrams all over the mirror in my bathroom, you know, and I studied it, and I know it.
Okay, so this is just.
And besides, I will be putting together my findings and sending it to DLNR and asking them to confirm or deny my findings. And it's so black and white, so.
Okay, so my understanding is this based on your self-study then?
Yes.
Regarding this issue. And it's your opinion that the U.S. Fish and Wildlife designation of that area is as wetlands is not correct?
It's not correct. Okay. But I'm recommending to my clients to respect and accept that designation for two reasons. Yeah. One, the 3.3 acres has always been in the I keep forgetting that zone, the green zone, and we had no intention, absolutely no intention of going vertical in that area. And the second reason is that I feel confident we can change the designation, but it'll probably take 3+ years to do it. And every year goes by, the cost of construction goes up. Every year goes by, the cost of affordable housing go up. So I'm recommending to my clients not to go there at that time and just accept it and move forward. Because we're not going to do anything there anyway.
Okay, you previously mentioned that, sorry, I'm not sure if I got this right. You previously mentioned that you were aware of there being a possibility of 0.3 wetlands in the area, but you said it wasn't in the petition area? Is that correct?
Not necessarily in the petition area. And as I look at the map, it's really close. It's really hard. You got to survey it to find out if it is or not.
Okay, so you know that there was a possibility of there being wetland, but you thought it wasn't in the petition area and you didn't
Correct.
check exactly.
And if it is, it's just a small portion of it.
Okay, prior to the 3.3 area being an issue, did you do anything else to, I guess, investigate the existence of wetlands in that area?
Only to the extent that I walked the site and felt comfortable of what we're doing at HoKua Place wasn't going to negatively impact the wetland areas and the adjacent land to the petition area.
And when you said your walkthrough, you mean before the 3.3 area was raised?
Yes, I walked the site early on, 2 years ago, and then I made a point of extensively walking the site after the 3.3 acres were discovered.
Okay, so you went to, after the 3.3 acres were discovered, you said you went to the actual area and took a look to see if there were wetlands? Is that correct?
Yes.
What date, around what date was that?
Excuse me?
When was that?
That was in late January, February.
January,
Maybe
February?
March. Yeah, I went there approximately 5 times after heavy rains, and I stayed there one evening to see if any birds would fly to it and rest there. I even went there one night with my flashlight to see if I could find any bats or any birds resting there at night. Some delicious doves I saw on there. I didn't see anything.
Ms. Kato, is that you typing, perhaps?
No.
Okay, someone's typing.
Sorry.
We're picking it up. Please continue.
I have 10.
Okay.
Actually, Chair, I'm sorry, there's something else that I wanted to mention. I'm not sure if it'll be an issue or not, but regarding the scheduling, Rodney Funakoshi will not be available from 3:45 p.m.
Okay,
Sorry, I wasn't aware of that before.
okay. I think we can proceed with just his counsel.
Okay. Okay. So there was a exhibit 37, which was a picture that you took of the wetlands. That's correct?
Correct.
When was that picture taken? Approximately.
I think I visited in late January, I think.
Okay, January. So when you went to look at the wetlands, did you go with any other person?
Yes, I met the State Fish and Wildlife Division, and I met with Dar from the Illinois.
Have you seen the Office of Planning's Exhibit 15?
What's Exhibit 15?
It's a series of pictures.
I'm not readily familiar with Exhibit 15. Could you describe it?
Maybe if I try to share my screen, but I'm not too sure how to. Oh, sorry, I'm gonna try and share my screen.
Okay, please go ahead.
With the exhibit. Do you see it?
Yes, photographs.
Okay, so these are, this is Exhibit 15 from the Office of Planning, and these are pictures that were taken of the wetland area. And so.
Yes, that's looking south of the Hawaiian Road. The body of waters you see over there is outside of the petition area and mostly outside of the property, actually.
You're saying that the pond is outside the petition area? Okay, sorry. It was my understanding that it was within the petition area. So that's not your understanding.
Right.
Sorry, did that work? Did I stop?
Yes, you stopped.
Okay, sorry. Have not done that before.
You passed with flying colors, Counselor.
Okay, so the wetlands areas, you're saying that you first became aware of there being wetland areas on the petition area only after you heard about the 3.3 acres?
Yes.
Okay. So after learning about the wetland, I understand that you went to the property to take a look and, met some other people, but did you have a qualified engineer or biologist examine the wetland area?
No, but I will put together my findings and I intend to send it over to the experts at the LNR. For them to, because nobody's going to listen to me officially. I mean, it's got to come from a government agency. I asked Fish and Wildlife. I asked extensively, a couple of times, for an extensive report from the Division of Wildlife who joined me to give me a report of what he saw out there, and they're not going to do it.
So regarding the location of the boundary of the petition area, you're saying that the pond in the exhibit was outside of the boundary. How do you know exactly where the boundary is on the land?
It parallels the Hawaiian Road that we were walking on.
Okay, so it's just by your visual. There's no GPS or property line staked out.
No, it's not staked out.
So it's a little. Would you say it's a little unclear exactly where the boundary is on the ground?
Oh, while I was walking there?
Mm-hmm.
Yeah, it was just a supposition. knowing where the Kane Hall Road was in relationship to the maps.
So is it possible that you may have been mistaken as to whether some of that water was within the petition area?
Of course, there's always a possibility.
Okay, and so
But yeah, there's a possibility.
Regarding the exact location of the wetlands in the petition area, do you intend to conduct a wetland delineation survey?
One would do that if one wants to challenge the designation. And we're not challenging the designation. We're going to respect it and accept it. So there's no need for it.
Okay, do you intend to do anything to determine where the exact boundaries of the wetlands are? Or are you relying on the U.S. Fish and Wildlife map?
Oh, I'm relying on the USDA map. Or you mean about the 3.8 acres? Yeah, I'm relying on Fish and Wildlife map.
Okay.
And it's okay. It's okay to do that.
Oh, so, with respect to mitigation measures, if you're not having a qualified engineer or biologist examine the area, how do you intend to determine what mitigation measures would be necessary with respect to the wetland area?
I have recommended, and I think I've got to go ahead on it, to work with Fish and Wildlife in a habitat restoration program.
Mm-hmm.
And are you familiar with the habitat restoration program, where we have the use of Fish and Wildlife experts to help us identify invasive plants and any contamination on the lot, and come up with a plan to clean the area if need be, or remove invasive species if need be. And that's part of the restoration plan that Fish and Wildlife offers.
Okay, so any mitigation measures that are suggested will, you think petitioner will agree to follow those?
Yes.
Okay. So have you seen the Office of Planning's Exhibit 16, which is a map showing a proposed buffer area around the wetlands?
Yes.
You have seen it?
Yes, I've seen it. But
Okay.
I'm going to be negotiating that line with Fish and Wildlife and the State Wildlife Division.
Ms. Kato, about how much longer?
15 minutes? Sorry. I added questions and it took a little longer.
Chair, can I ask for an offer of proof?
Can you expand on that, Mr. Okuda, Commissioner Okuda?
In other words, what are the points council are trying to make? At this point in time, it might be cumulative.
My concern is without prejudicing the Office of Planning's points, but I am trying to understand where you're going and how that's getting us to really the first hurdle we must overcome, which is whether or not the petitioner has at a minimum met their burden.
Okay, sorry, our concern is just that, we did not know about these wetlands. We have not been able to really receive comments on it. And we just want to know where the wetlands are and if it's being appropriately addressed.
So I have gathered, at least from your cross of Mr. Agor so far, that he can't, while he has visited the site, he cannot definitively state where they are. And he states that most of his addressing of these matters will be in the future. But he has nothing currently to describe his mitigation or his counteracting
Okay.
or disagreement with the previous determinations of the existence of wetlands.
Okay, and my current questioning regarding the proposed buffer area is to see if the petitioner would be willing to agree to a buffer area adjacent to the wetlands that Lots Pine has proposed.
So if you can go there as directly as possible.
Okay,
You want me to answer that question?
yes, please.
Yes, I'm going to agree to a buffer, but that exact location may not be there. Yeah, because nationally, in non-sensitive wetland areas, the average buffer distance is between approximately 50 feet. And on very sensitive wetlands, they range anywhere from 75 feet to 150 feet. So I'd like to negotiate like a 20-foot, 25-foot buffer after I get a response from DLNR on verifying my findings of the wetland. Yeah, and I'm confident that, of course, this is just suppositions, but I'm confident that they're going to find my research on it has been correct, and we could label.
I'm going to, for the efficiency of these proceedings.
Okay. All right, that's it. Sorry, I rambled on.
Okay, sorry. Yes, we can move on. During construction, I understand that there's going to be mitigation measures such as you will be putting up a construction fence to prevent seabirds from moving into the construction area, is that correct?
Yes. In my discussion with wildlife representatives from the state, we talked about reinforcing the wire fence on the left-hand side of the road, the Hawaiian road, to keep any species from going up to the construction site. And we also talked about providing fencing to keep animals and people from going down to the wetlands along the boundaries of the Greenbelt area.
Okay, and this is
which would protect.
I'm going to ask the witness to really answer as simply as possible the question that's asked to them. Can you repeat the question, Ms. Kato?
I just want to confirm that they're willing to put up sufficient construction fence to keep seabirds from moving into the construction area.
And yes, no, or I don't know is a sufficient answer.
Yes.
Okay, thank you. And also you mentioned it too, but you will also be putting up a permanent fence to keep animals such as dogs and I guess feral cats from entering and attacking seabirds. Okay, thank you. And this fence will also include proper signage, correct?
Yes.
With respect to the developing a plan preventing feral cats and other predators from entering the wetlands, will this include a prohibition on feeding feral cats and establishing and maintaining feral cat colonies within the petition area at HoKua Place?
Yes, we've already discussed that with, I've already discussed that with the clients and we're going to have that in the
Again, yes, no, or I don't know, unless it really requires some expansion.
Yes.
Okay, thank you. I will try to move it on more quickly. Let's see. Okay, so I didn't see this in the statements regarding the conditions, but regarding invasive species, will the petitioner contact and consult with the Kauai Invasive Species Committee to minimize the risk of spreading invasive species?
Yes.
Okay, so does your habitat restoration plan include any, I guess, establishment and continued maintenance of native wetland vegetation?
Yes.
Okay, thank you. So one of your areas listed is flora. So regarding the vegetation and plants in the petition area, I understand that but a botanical survey was performed on the petition area in May 2012. Is that correct?
I believe so.
Okay, so the survey states that several transects were done. Approximately how far, do you know how far apart those transects were?
No, I don't.
Okay. It was a conclusion that no threatened or endangered species plants were found, though, correct?
Repeat the question.
Actually, that's fine. I'm going to move on. With respect to the indigenous plants, 3 indigenous plants were identified. Is that correct?
By the experts, yes.
Okay. During cross-examination of Nancy McMahon, she stated that she did see some of those indigenous plants and that there are Native Hawaiian cultural uses for those plants. For example, one of them she mentioned had medicinal uses. Were there any efforts made to identify cultural or traditional uses for these plants?
No.
Okay. Were there any efforts made to determine the availability of these indigenous plants outside of the petition area?
Not yet.
Okay. Thank you. That's all the questions I have. Thank you very much.
Thank you very much, Ms. Kato. Intervener, and again, I would like to keep these proceedings as efficient as possible. Mr. Collins.
Thank you, Mr. Chair. Good afternoon, Mr. Gore.
Good afternoon.
I just want to say, just before we begin, that I wanted to thank you for being part of the group that picked the Centennial logo. I thought it was beautiful and represented the year very well. So thank you. I've never had the opportunity to thank you. I'm going to be asking you mostly yes or no questions, and I've had an opportunity to refine my questions so that we can try to get through the questions sooner than later. So I apologize if I seem impolite. I just would like to get through the questions in response to the chair's desire. Okay. The first question is, did you tell William Bao not to include his revised drainage detention plan, the one submitted as Exhibit P27 this February, as part of the final EIS? Yes or no?
No.
You discussed the county general plan in your presentation, your direct examination. Did you examine the consistency of this project with the applicable community development plan? Yes or no?
No.
Will the developer have a declaration of covenants, conditions, and restrictions, or some other instrument to ensure its representations about uses of the homes are enforced?
It will be, yes.
Okay. Does the EIS or petition address uses of homes as transient vacation rentals?
No.
What about the addition of accessory dwelling units on single-family unit lots?
I can't answer that.
Okay. Does the EIS concede that there are unmitigatable traffic impacts such that the community would have to stay home during peak traffic hours or sit in heavy traffic?
Most probably.
Okay. Does the petitioner have an agreement or letter from the County Public Works Department agreeing to provide capacity to HoKua Place with respect to wastewater?
There's no agreement.
Okay. Did you respond to comments on infrastructure in the EIS by stating, quote, HoKua Place will not have a major impact on infrastructure? As stated in the second draft EIS and the final EIS, the county wastewater department have accepted the project with the developer assisting in the maintenance of the sewage treatment plant, end quote.
Yes.
Okay. Did you also respond to public comments stating, quote, infrastructure is adequate for this project as DOW have been offered to take over the potable water well, which will provide all of HoKua. The county wastewater treatment plant for the area has the capacity to handle the project, end quote.
Yes.
Isn't it also the case that the county wastewater's comment on the EIS was, quote, there may need to be improvements at the WWTP prior to the county having adequate capacity for full build out of the project, end quote.
Yes.
Is it still the petitioner's position that the county wastewater treatment plant will have capacity for the project?
Yes.
Did you respond to commenters' concerns about overdevelopment by saying the developer wants to help the housing crisis and walked away from, quote, big bucks, specifically referencing rich people ag subdivision?
Can't remember.
Okay. Did you remember saying, quote, you need to know that the developer originally had an ag subdivision about to be approved and ready to go to market? It consists.
Yes.
Okay. Thank you. In your response to public comments, did you state, quote, it is anticipated that many of the homes in HoKua will be filled with families currently doubling up, so the people are already in the area. Many of them will have the opportunity to be relocated in well-designed housing complex. Thus, the island's solid waste facilities will be minimally impacted, end quote?
Yes.
Okay. But doesn't it also say in the economic opportunities portion of the sustainability plan, quote, development of facilities would generate employment and consequent income and taxes. In addition, by providing the opportunities for new residents to the island of Kauai and generating additional real estate activity, the project is expected to support long-term impacts, including additional consumer expenditures, employment opportunities, personal income, and government revenue enhancements, end quotes.
Yes.
So the project isn't to be sold to doubled up local families exclusively, but also to new residents that would impact infrastructural services, correct?
Most likely.
Okay. Substantially all of your responses to comments cited, quote, 231 affordable units in the range of 175,000 to 275,000 with respect to affordable housing. Is that correct?
That's correct.
But doesn't Cassidy's market study say that affordables will be 225,000 to 325,000?
Hello.
Would you like me to repeat the question?
Please.
But didn't Cassidy's market study say that affordables will be from $225,000 to $325,000?
Gosh, it's hard to answer yes or no without an explanation, but yes.
Okay, your attorney is totally free to re-examine you on any of these if you feel that the yes or no somehow needs further explanation. And so Cassidy's market study information is not in the FEIS, is it?
No.
Okay, but this is a substantive change, correct?
Yes.
Okay. Has HoKua Place planned or considered providing a performance bond for LUC approval?
No.
Okay. Your engineer, Mr. Bao, said that infrastructure costs are based on the per acre infrastructure costs from 2 Kauai developments he worked on, Kauai, Makana, and Huaka'i. Is that right?
Yes.
Isn't it true that these workforce housing developments are on land without any significant slope?
Yes.
Are you aware that there is available utilities, sewer, and water service hookups for these 2 other projects already?
No.
No. Okay. Were you responsible for you were responsible for preparing the environmental impact statement documents, correct? That was your testimony during direct examination?
No.
No.
It's hard to answer.
So
was the manager.
You're the manager. Do the documents discuss wetlands or native wetland birds, including any of the botanical or biological surveys?
Yes.
Okay. Did the U.S. Fish and Wildlife Service comment on the existence of native wetlands in response to the EIS?
No.
Okay. So they did not specifically say that the detention basin would be an attractive nuisance for listed wetland birds in the area?
No.
Okay. Ms. McMahon stated that her trenching map is in an archaeological assessment in the EIS. Are you familiar with that at all?
No.
Okay. The FEIS discusses the availability of healthcare services by pointing to the Mahelona Medical Center. How many ICU beds does that medical center have?
I don't know.
Okay. Do you know how many ICU beds there are on Kauai total?
No, I don't.
Okay. The FEIS states that, quote, subdivision approval improvements, including roads, water system, wastewater, utilities, and other improvements, quote, are estimated at 22 million. Is that correct?
I need to verify that.
Okay. Could you take a look at Petitioners Exhibit 4 at page 20?
Yes, it was stated that.
Okay, great. But does the FEIS also refer to, quote, Road A as a new connector road between Olohana Road and the Kapaa Bypass Road, end quote, and states that, quote, construction cost of the connector road was estimated at $25,824,000, end quote? That's at page 128.
Correct, it certainly stated that.
Okay. In Cassidy's report, he refers to infrastructure being $82,931,400, not including vertical construction, which would be an additional $218 million. Do you agree that $22 million that's stated in the 2019 FEIS is nowhere near the 83 million that's in the Cassidy report?
Yes.
Okay. Did you indicate at any time that homeowner association fees for multifamily units would be between $800 and $1,200 per month?
No.
Okay. Is the HoKua Place Water Master Plan in the FEIS?
Yes.
Okay. Does the Water Master Plan include plans for storage?
Yes.
Does the Water Master Plan include contingency plans if the well is not productive?
I can't answer that.
Okay. Was the discussion with KDOW regarding the Water Master Plan for 50 farm dwelling units and goat raising operations?
I can't answer that.
Okay. I'll skip over these. Are you able to answer questions about financing?
No.
Okay, I'll skip over all of those. Are the wetland buffer, protective fencing for wetland birds, feral cat plan, or habitat restoration plan in the EIS?
No.
Okay. Are you aware that the county code allows the county to exempt a developer from affordable housing requirements if the land is zoned R10 or greater density?
Yes, I'm aware of that.
Okay. In your PowerPoint, you read the statement that the project satisfies the Kapa'akaio test. What are the elements of the Kapa'akaio test?
I don't know that offhand.
Okay, but you are sure that the project satisfies the Kapa'akaio test?
From my consultants, yes.
Okay, which consultant is that?
Nancy McMahon, for one.
Okay. Are there others?
Not that I know.
Okay. How did you folks get the name HoKua Place?
HoKua Place was discussed with Mr. Allen and myself, and really it refers to looking out and seeing the horizon meeting the sky, and certainly from HoKua, looking out, you will see the horizon of the ocean, and its integration with the sky. And sometimes you don't know the difference between the sky and the ocean, or something like that.
Okay, and I'm sorry, you said, and Michelle, which Michelle is that?
No, I didn't say Michelle.
Oh, I'm sorry, you said that you discussed this with somebody else?
Oh, with the Allen family.
Oh, the Allen family. Okay, sorry, I misunderstood.
Yes. At the time, they were the sole owners. I spoke with them about it.
Sure, and this is you're talking about the Allen family that's like Greg Allen and his family?
Yes.
Okay. Thank you very much, Mr. Agor, for allowing us to move through this quickly. I appreciate it very much, Mr. Chair. We have no further questions for this witness. Thank you.
Thank you. I appreciate it very much as well, to both the witness and to the intervener. Commissioners, can I get a show of hands of how many people might have questions for the witness? Commissioner Chang, Commissioner Giovanni. About how long do you think you have?
5 minutes.
Commissioner Chang?
Likewise, and I might not even have a question after I hear Commissioner Giovanni.
Okay. Let's continue on. See whether we can finish at least with the commissioner's cross. Commissioner Giovanni.
Sure. And thank you, Mr. Agor, for being here today. In view of the time constraints on us today and our interest to move efficiently, I'm going to confine my questions to this one narrow area. And that has to do with your remarks regarding the general plan. So can you state for me your familiarity, involvement, and understanding of the general plan? 18, you referred to that as the new general plan.
Yes, I kept track of the update of the general plan, and the outcome of the general plan listed 4 visions and 19 policies to affect what the general plan and the community has said that Kauai would be like.
So I'm going to quote from the general plan. You tell me if you agree with this, your understanding consistent with this quote. Quote, the vision and goals are aspirational in nature. They describe Kauai's ideal and desired state by the year 2035, end of quote. That sound familiar from your understanding in the general plan? I'm going to quote again. It says, the general plan covers 6 planning districts on the island of Kauai: North Shore, East Kauai, Lihue, South Kauai, Hanapepe Eleele, and Waimea Kekaha, end of quote. That sound familiar?
Correct. Yes.
The general plan goes on to refer to a community plan also referred to as developmental plans. Does that ring a bell with you? Do you know what I'm talking about when I refer to a community plan?
Correct. I don't believe they completed that plan yet.
So let me quote, community plans means a public document that provides specific proposals for future land uses, developments, public improvements, given community within the county of Kauai. Does that sound familiar? What the intent is of a community plan?
Correct. But gosh, I'll just say correct.
Okay, fair enough. And community plans are intended to be region specific and capture the community's vision for the area. Does that sound familiar?
Right. Right.
Has a community plan been produced and made public for the East Kauai community based on the general plan?
At the time of the submittal of the final EIS, the county had and the community had not finalized the east side community plan. And right now, I don't know if they've completed it yet or not. They may have, but I'm not aware of it.
I'm aware that they have not. It's not been done. It's been completed for other districts, but not East Kauai. And one of my concerns is that's really the step in the planning process where a general plan goes from aspirational to specific, and where the community gets an opportunity to really share its vision for the plans for the area in which they live, which has not occurred as of yet for East Kauai. Would that surprise you, or would you disagree with me?
Oh, I agree with you, and hopefully it's done before we go through the entitlement process with the county.
Well, one of my concerns is that there are representations in the testimony of the petitioner that this should move forward before the LUC because it's consistent with the aspirational, my words, not the petitioner's terms of the general plan. And yet we don't have a community plan, and instead what we've heard from an unbelievable, in my view, number of community participants in this docket is that they never really had an opportunity to participate in the planning process and to weigh in on this specific project, despite your representations of outreach. Would you disagree with me, or would you want to describe it differently?
No, I do agree with you, but there is a mechanism where the community can have their input during the entitlement process. And they could have the possibility of shutting the project down, depending on how valid their concerns are. And I'm hoping that the Wailua community plan is done by that time.
So here we are today. Here we are today. The community plan has not been developed, and yet you're asking to the Land Use Commission to grant a redistricting of this area, largely based on the aspirational perspectives expressed in the general plan. Would you agree that we would be in a far better position today at the Land Use Commission to take up a matter such as this if we had the benefit of a community plan that had the input of residents and a lot of community input to that plan?
We certainly would be, but that doesn't prohibit, being that we don't have it, that doesn't prohibit us to move forward, because like I said, there's another mechanism for the community to have their input.
Yeah, my question was not whether we're prohibited from moving forward. I don't think we're prohibited. I would agree with you on that. My question was, wouldn't we be far better off if we had a community plan to rely on for the decision-making that's being asked of this commission today relative to this project?
Absolutely, sir.
Thank you. Nothing further, Chair.
Thank you very much, Commissioner Giovanni. Commissioner Chang.
Thank you. Thank you very much, Mr. Gordon. Nice to see you here today and appreciate your testimony. I just have one question for you. I want to just confirm that the consultant who has the knowledge and expertise regarding the Kapa'akai analysis is Nancy McMahon and not yourself.
Yes, it's Nancy McMahon.
All right, that's all the question I have. Thank you so very much.
Thank you. Is there anything further, commissioners? Mr. Ewan, is there any redirect of Mr. Agor?
No redirect.
Hey, it is 3:15. I want to take a 10-minute break. Are there any commissioners who intend to ask for Mr. Bracken's appearance? Do you intend to recall Mr. Bracken, Mr. Ewan?
Yes, I do.
He's available in 10 minutes?
I'd have to give him a call to verify. I did speak to him earlier today.
I thought you had assured me that he was available in the afternoon.
He did say he was available. I have to call and confirm that he.
Okay.
Can you see if he's a participant? I know he was on.
Mr. Collins?
I was just going to note that he's as listed as an attendee
Oh, and
presently.
he's raised his hand. I'm promoting him to be a panelist. It's 3:16. We will reconvene for the recall of Mr. Bracken at 3:26. And that should be the conclusion of the petitioner's witnesses and evidentiary presentations. Recess till 3:26. Okay. Let's get going. It is 3:26.
Okay.
Mr. Ewan, we can't actually see you. And we're waiting for Commissioner Giovanni to reappear. I can now, yeah, there we go. Okay, we have Commissioner Giovanni. We just need, it'd be good to be able to see you, Mr. Ewan.
Great.
Mr. Ewan? Okay, I'm going to note the presence of Deputy Attorney General Brian Yee as well. Okay. Mr. Ewan, you've recalled Mr. Bracken. Mr. Bracken, you remain under oath.
Yes, Mr. Bracken? Can
Yes.
you hear me?
Yep, I can hear you.
Okay. Mr. Bracken, first, we had put into evidence and marked as Exhibit 46.
Sorry, Mr. Ewan.
Yeah, I know, I gotta. Okay. We had marked as exhibit number 46, your contract with Randall Okaneku to perform a traffic study for this project. Did you see this exhibit, Mr. Bracken?
Yes, I did.
And is this your contract with Mr. Okaneku?
Yes, that is.
Mr. Chairman, we'd like to introduce it into evidence at this time.
Any objection from the county?
No, Chair, thank you.
OP.
No, thank you.
Intervener.
No, thank you.
Commissioners? So admitted.
Thank you. Mr. Bracken, have you seen exhibit number 44, which is the development cost estimate prepared by Mr. Agor?
Yes, I have.
Could you explain to the commission how you intend to finance the development of this project?
Well, as we've already stated, we have secured some significant lines of credit already. We've expended some significant funds to date. So we have approximately $30 million available for the project to get going. We have spent in excess of $10 million to date in acquiring the land and, getting us to this point. In addition to that, we do plan on getting as much traditional financing as we can. As we are aware, we are involved in other real estate projects that are currently profitable and are cash flowing. And in fact, we do have the ability from existing operations at sister projects to cover those same cash flows as well. But our goal, our plan would be to utilize as much traditional financing as possible at that point.
Now, the exhibit prepared by Mr. Agor shows approximately total project cost of $320 million, but 25% of that, or approximately $85 million, would be utilized at any one time at a maximum. Could you explain how you would see your particular cash flow issues with that portion, and whether you would enlist other development partners or contractors?
Yeah, we are not a licensed contractor in Hawaii, so we certainly would be relying on and looking to either partner or sell some of those lots to local contractors for the vertical construction. That's typically how we do much of our development. Is we do the land development and then we partner or sell the lots for contractors on the vertical construction, and that would be consistent with how we've worked in the past.
So a good portion of the $85 million at any one time outstanding would consist of the actual improvements to the property and the multifamily homes to be built. Is that your understanding?
Yes, that's my understanding.
So you would not be financing that portion directly yourself. Is that true?
That is true.
I'd like to turn to another area, and that is there has been some discussion about the having you as the master developer post a bond for completion of this project. Can you explain to the commission whether that kind of thing would be possible or desirable from your perspective?
We have, looked into that as much as we can. The problem we have, or the concern that I see with that is we are just not at that point yet. For a performance bond, usually we need to have designs, we need to have cost breakdowns, we need to have, more firm numbers to take that to the person who would be issuing that bond. And when we haven't gotten to that point yet because we don't know the constraints, that from both the Land Use Commission and the county level that we need to do that planning around. We've got a general concept, but once we kind of know what the constraints are on what our boundaries are going to be and what the number of units we really is appropriate, then we can design with those constraints in mind, and that would be a more appropriate time for something like that is when we had those construction drawings in hand and we were working with this at the county level.
And you have, of course, posted bonds in the past in your other developments. developments, have you not?
Yeah, I would say it is very common. Anytime we're building infrastructure, roads, utilities, we've almost always had to post a bond. Not only a performance bond, but oftentimes some form of a holdback or warranty bond for a period of time for those municipalities.
And so the appropriate time when a bond like this is posted would be at the subdivision level? Is that your understanding?
That's my experience.
And not at a preliminary stage where the county has not imposed any design requirements on you to date?
Yes.
I have no further questions.
Thank you. County.
Thank you, Chair. Mr. Bracken, just
sorry, give me a sense of how long you think you might want.
I just want to cover one thing on the Exhibit 44.
Thank you.
One item based on the testimony of Mr. Nance. Mr. Bracken, on page 1 of Exhibit 44, which is the concept cost estimate, there's a primary infrastructure well development, and it says unit cost $1 million. Are you familiar with that?
I don't have it in front of me, but that sounds appropriate.
Okay, so if Mr. Nance testified earlier that the initial well was not approved, and so abandonment has to be done and it has to be completed, and then another well approved and drilled, which would increase the cost potentially of he said at the very least $500,000. Would that throw off this cost, or would that be covered in where it says 20% contingency of 1.991300?
My understanding is it would come off this cost.
It would come off the $1 million. So that includes the already unapproved well.
Yes, I believe if I'm understanding right, we were suggesting $500,000 as a rough cost for drilling the new well, and I believe it was $250,000 to take care of the old well. And again, we're still preliminary. We are adding a contingency there, but I believe that the $1 million is covered under that.
Okay, so that covers both wells. Okay, thank you. I have nothing further. Thank you, Mr. Bracken. Thank you, Chair.
Mr. Donahoe. Office of Planning. Will this be Ms. Kato or Mr. Yee?
Ms. Kato. I have no questions. Thank you.
Thank you. Intervener, Mr. Collins or Ms. Isaki?
Mr. Chair,
yes.
We have a few questions in cross-examination for this witness.
About how long do you think?
Hopefully not more than 5 minutes.
Please proceed.
Thank you. Good afternoon, Mr. Bracken.
Good afternoon.
I have a few questions. You previously represented that petitioner has access to a $5 million revolving loan shared between Roach Enterprises, Hurricane Hills, and HG Joint Venture, correct?
Correct.
And Hurricane Hills is developing a project called Sand Hollow Resort in Hurricane, Utah?
Yep.
And it has basically access to that same $5 million of the revolving loan, right?
We have not been using it. We used Sand Hollow Resort.
Okay, sorry, my question is
collateral.
Yeah, I'm sorry. My question is, but it has access to that same $5 million, correct?
I guess, yes, it could.
Okay.
From an entity level, no, but yes, I'll give you that.
Okay, well, you just said that the $5 million loan is shared between Roach Enterprises, Hurricane Hills, and HG Joint Ventures, so.
Yes, those are the guarantors on the loan.
Got it. Okay. The commissioner's deed indicates that the property was paid for at $4 million at the foreclosure sale, but that you valued the property on the balance sheet at $10.6 million. Is that correct?
I believe that is correct.
Okay, and then you had said that I guess $6 million was because of a second position that was a $6 million note. Is that correct?
I don't remember the details, but it came from a second position note that we acquired at the time.
Okay. Do you recall what the face value of that note was?
I don't know that offhand, no.
Okay, but for bidding purposes, you are allowed to bid 6 million. That note was allowed to include 6 million in the credit bid?
I don't remember that. It was 2013. I don't remember where we were on that.
Okay. And the commissioner's deed indicates that the conveyance tax was $28,000 paid. And I guess computing that, it shows that conveyance tax was paid on $4 million, that the transaction value is $4 million. Is that correct?
That sounds about correct. I don't believe
Sure.
there was much bidding after the first position note.
Okay. How was this other note extinguished? How was the extinguishing of it characterized to the IRS? Was there a net gain or a net loss?
I don't remember what that was at the time. It was contributed and is as part of equity into HG Kauai joint venture, but I don't remember the tax treatment.
Okay. Okay. Are you aware of HRS 247-2 that says the conveyance tax is, quote, based on the actual and full consideration, whether cash or otherwise, including any promise, act, forbearance, property interest, value, gain, advantage, benefit, or profit, paid or to be paid for all transfers or conveyance of realty or any interest therein?
Okay, I understand what you're saying.
Okay, okay. And so if the conveyance tax was paid on $4 million, that means that the value, this other $6 million value, was not reported to the Department of Taxation for conveyance tax purposes.
I don't know what was, how it was done. Again, this was 2013, but I believe that the value for conveyance tax purposes was the auction value that it was sold at.
Okay. Even though HRS 247.
Is that your phone, Mr. Ewan?
Yes, I shut it off.
Please.
Even though HRS 247-2 says that conveyance tax is supposed to be computed on the total value of the transfer.
Again, this is going back in time quite a bit. I would say that our transfer value was the auction value. We acquired the second position note at an earlier time.
Mr. Collins, can I ask, I'm not saying that these are not interesting issues, but I'm trying to get to how this relates to our proceedings.
Sure, I have one last question and I'm done. But this does relate because this is being put in terms. So my last question will indicate the relationship of all of this to what's going on.
Proceed.
So that was in 2013. Presently, you testified previously that the value of this property is being valued on the balance sheet as $10 million because of something that happened in 2013, but you are not able to explain how this other $6 million was reported to any tax authority as actually existing in 2013.
Well, all I can say is we reported it and we structured the transaction according to our legal and tax advice at the time. I can't tell you the details here, 8 years later. I don't know that offhand.
But it is on your balance sheet presently.
It is on our balance sheet presently.
Okay.
Yes.
Thank you very much.
I don't have a history though.
Thank you very much, Mr. Bracken. We have no further questions. Thank you.
Is there any questions from the commissioners for Mr. Bracken? Are there? Excuse me. Commissioner Chang?
Thank you, Mr. Chair. I'm going to try to keep my questions really short, Mr. Bracken. I want to ask you about Exhibit 44. The $83 million for the infrastructure costs, does that include any traffic upgrades if they're required?
I don't know offhand. I don't know. It was our engineer's best guess of the total, so I assume that it does, but I can't say for sure.
Okay. I'm looking at the exhibit right now, and it doesn't appear to. But okay, does your $83 million include any wetland mitigation? Since Mr. Agor said he will accept the wetland designation.
I believe that the intent was all of the costs that we were expecting based on their experience. So I couldn't tell you specifics, but other than these are the best estimates at this time from my professionals that are advising me.
Okay. The last question is about the performance bond.
Yes.
What I understand your testimony is that it's premature because it's not, you don't have development plans at this point in time, and it's too early to tell. Is that what you're saying?
Yes, and in particular, a bonding agent, somebody who would be issuing a bond would want something to bond again, you know, specific plans for what they would be bonding for. Right now we've got, you know, guesses, back of the napkin, you know, our best guesses of what things are going to look like, and we don't have a specific, you know, plan to bond against.
Okay, well, this is a pretty nice napkin that you gave to us on Exhibit 44. You've given us vertical construction costs of almost $212 million. What is that based on?
That was based on, I think a lot of Rick Cassidy and Ron Gore got together, and they were basing that on you know, your average vertical construction costs.
It's
and they making assumptions based on the number of units and their best guess of square footage.
But you must have, all you have is just numbers. You don't have any, you're telling me you don't have any designs. You just have total number of units.
Yeah, I believe they took total number of units and their best guess on an average unit size and used, you know, average square foot cost to come to that, which is typically how I would do this sort of an assessment myself.
Okay, thank you very much. I have no further questions.
Thank you.
Commissioners, any further questions for Mr. Bracken? Seeing none, any redirect, Mr. Ewan?
I have none.
Okay, thank you very much, Mr. Bracken.
Thank you, Chair. Thank you, everybody, commissioners.
The petitioner now having admitted all their exhibits and called all of their witnesses and recalled Mr. Bracken, we would next normally proceed to the presentation of the case by the county. Mr. Collins?
Mr. Chair, at the appropriate time before the county begins its thing, we would like to make a motion.
Let me finish at this point, Mr. Collins, with what I was going to say. A number of the commissioners on the county's presentation, a number of the commissioners have already, during the presentation of the petitioner's case, have expressed some significant concerns, and I'd like to give the commission a moment to discuss these matters. Commissioner Okuda.
Well, thank you very much, Mr. Chair. First, if I can ask Mr. Ewan so the record is clear, has the petitioner rested its case?
Yes.
Mr. Chair, that being the case, that the petitioner has rested its case, I make a motion to dismiss or deny this petition. If my motion is seconded, I will spell out in detail the reasons in support of my motion.
Commissioners, there's a motion before us. Commissioner Giovanni?
I second the motion.
Okay, Commissioner Okuda, please speak to, and I hope in great detail, explain the reasons for your motion, and then I'll give it a chance for the seconder to speak to the motion, and then we'll move into discussion.
As we all know, the Land Use Commission is a quasi-judicial body that is required by statute, specifically the Hawaii version of the Administrative Procedures Act, to make its decisions based on the law and the evidence which is adduced properly under the statute. What that basically means in plain English is we as individuals are to put aside whatever prejudices or biases or whatever we have, look at the law and apply the law fairly without favor or prejudice based on the evidence adduced. And the guiding point of our actions in a boundary amendment case comes from HRS section 205-4 subparent H. And what that says is basically this, and I quote, parent, small h, close parent. No amendment of a land use district boundary shall be approved unless the commission finds upon the clear preponderance of the evidence that the proposed boundary is reasonable, not violative of section 205-2 and part 3 of this chapter, and consistent with the policies and criteria established pursuant to sections 205-16 and 205-17. Now, with respect to the process or procedure that we are to follow here, both the Administrative Procedures Act as enacted in Hawaii, Chapter 91, and also the Hawaii Administrative Rules set forth the process in the conduct of the hearing. And that's specifically HAR section 15-15-59, which states the following, and I quote, parent, small a, close parent. The hearing shall be conducted in accordance with this subchapter, period. Unless otherwise provided by law, the party initiating the proceeding shall have the burden of proof, including the burden of producing evidence and the burden of persuasion. That basically means that the petitioner seeking the boundary amendment has the burden of proof, the burden of persuasion, and the burden coming forth with the evidence. I would also note that section HAR 15-15-41 allows parties or the Land Use Commission to bring a motion to dismiss a petition if such petition or document is insufficient, but that is not the only basis upon which such a motion to dismiss can be brought. In this case here, I believe even taking a very easy or looking the other way and trying to view things somewhat in the light most favorable to the petitioner simply has not met its burden of proof. And these are some of the bases, and I hesitate on giving the entire laundry list, which is documented in the transcripts, because frankly, I think we'd be here a long time. One of the major defects is the fact that the final environmental impact statement simply does not satisfy the standards under the law. And one of the standards we have to look at is HAR, Hawaii Administrative Rules, section 11-200.1-30. That's the section of the administrative rules that deal with when a supplemental environmental impact statement is required. And I quote from subparagraph A in that section. It says this, quote, if there is any change in any of these characteristics which may have a significant effect, the original EIS that was changed shall no longer be valid, because an essentially different action would be under consideration, and a supplemental EIS shall be prepared and reviewed as provided by this chapter. And it goes on that if you don't have these types of substantial changes, you don't have to file a supplemental environmental impact statement. The Hawaii Supreme Court has made clear that these requirements under the statute governing environmental impact statements and the administrative rules, they really mean something. And for example, I believe the Kuilima Development Company found that out in the case which I have quoted before, or cited before, Unite Here! Local 5 versus City and County of Honolulu, which is found at 123 Hawaii Reports 150, specifically page 181, and the Pacific Third citation is 231 Pacific Third 423 at 454, which is a 2010 rather, Hawaii Supreme Court case, makes clear that where the environmental impact statement no longer reflects what really is going on, the agency cannot go forward, and in fact, the agency's decision will be reversed unless there's a supplemental environmental impact statement filed, or unless remedial matters regarding the environmental impact statement are submitted. And you know, the record is replete with the fact that this environmental impact statement is either insufficient as a matter of law or requires supplementation as a matter of law. And I went back, and I assure everyone, I've gone back and I've read the transcripts just to be sure that my recollection is not wrong. So I'm not relying on my recollection, I'm relying on the transcript. And for example, this was a question, and I'm not going to read the whole section of the transcript, but from my questioning of Mr. Bao, and this is the March 25th, 2021 transcript at page 193. The section really starts at line 2 through page 194, line 8. But at the ending of my questions, I asked Mr. Bao, and this is regarding the fact that the environmental impact statement did not have certain informations about the wetlands. My question to him was this, and I quote, "Do you believe, based on your experience in your profession, including your experience with environmental impact statements, that this is the type of information that should be included in an environmental impact statement, question mark?" And his answer was, yes, I would say so. Mr. Bao at the March 25, 21 transcript, page 183, lines 3 through 18, admitted that rainfall data really needed to be updated because that is the increase in rainfall is relevant and affects his drainage calculations. That's basically one ground. There are other things.
Commissioner Okuda, I
Yes.
do want to, given our time constraints, I want to have you speak to your motion and also give time for deliberation.
Oh, okay. Very quickly, the chair asked Mr. Winchester about whether or not his report satisfied HAR 15-15-50, part 24. He admitted that's the March 25th transcript at page 159, lines 5 through 15, that his report simply did not comply with that statute. I'm not going to go and repeat the Kapa'akai analysis or Kapa'akai issues. Let me just say this. I believe the colloquy and answers to Commissioner Chang's questions about Kapa'akai demonstrate that there simply was not compliance with the Kapa'akai standards. And as the Mauna Kea 2 case made clear, that's 143 Hawaii 379 at 397. It's not, the Kapa'akai standards are not simply regarding traditional and customary Native Hawaiian rights or the impact on it. It deals with to the extent which cultural resources in general are impacted. And there's simply failure to comply with that. My final point is this. Compliance with Kapa'akai is not simply a Hawaiian matter. That's part of the 1978 Constitutional Convention, where Native Hawaiians did not comprise very many of the delegates. The provisions in the Constitution, which we are trying to implement here or comply with here in these hearings, these are statements of the broad rainbow of people in the community who believe that protection of these cultural rights, protection of resources, and frankly, following these procedures that are set forth by law these are common goals and aspirations. So, Mr. Chair, for those reasons, and by the way, let me just say one last thing here. I find really a problem with the final environmental impact statement, Mr. Bao's testimony, that he had brought up a number of these facts before the final EIS was sent to the commission. And he was basically told that, and I can quote the section from the transcript, we are basically too far in, close quote, to include his comments, his updated drainage plan in the final environmental impact statement. I think there's an issue here about whether we have a material omission of fact under the case AIG versus Bateman, BATMAN. So that's some of the basis, Mr. Chair, in support of my motion. Thank you.
Commissioner Giovanni, you seconded the motion.
Thank you, Chair. I did second the motion. And I also agree with Commissioner Okuda that in his motion to dismiss this petition before the LUC. I'm not going to go into all the detail that Mr. Okuda did, but let me just say that I'm a student of Mr. Okuda's teachings, and I understand and appreciate and concur with the perspectives that he's brought forth in support of this motion. My areas of concern are in three general categories. One is the FEIS that we accepted in late 2019. At the time, the chair remarked that we were approving that FEIS, recognizing that it was a very low bar and they had just barely creeped over the edge of it. What I have learned in the evidence that's been brought forth in this docket has convinced me that they did not meet that bar at the time. And that if I knew then what I know now, I would have argued strenuously not to accept the FEIS at the time. Secondly, I think that the proposed project is in conflict with the will of the community at large, and that would be most directly affected by this project on Kauai. And thirdly, has to do with whether or not they've met the burden of persuasion at this point in this juncture in this docket, and I feel they have not. And my concerns are in many different areas, and the more I learn, and we haven't even gotten to the case from the intervener and others, whether it be traffic, wastewater, stormwater, infrastructure, the wetlands, and whether or not this really does constitute affordable housing that would be taken up by the residents of Kauai at this time, at this place. These are all big areas in which I have not been persuaded that this project is in the best interest of our community. And therefore, I urge my fellow commissioners to join with Mr. Okuda and myself and vote in favor of this motion. Thank you.
Before I call on Commissioner Chan, I just want to acknowledge that I indicated to the intervener that I was wanting to provide time for the commissioners to discuss. The intervener suggested they wished to make a motion. I'm going to just offer the opportunity very briefly for the intervener to say anything at this time if they wish to.
Mr. Chair, we were going to make a motion to do exactly what is now before the commission. We just wanted to note procedurally that we believe under the case of Kim v. State 62 Hawaii 483 that the commission has the authority to do this procedure at the close of the petitioner's case where no right to relief has been demonstrated.
Thank you.
And also that for the other procedural proposition that that you folks may weigh and evaluate the evidence without special inferences favoring the petitioner, resolve conflicts therein, and determine whether the clear preponderance of the evidence has been met.
Thank you. Having made an oral motion or indicated you want to make a motion, I want to and cut you off. I want to make sure you had an opportunity to speak. Commissioner Chang.
Thank you, Mr. Chair, and I will try to keep my comments very brief as I know others would like to speak. I too will be joining, supporting the motion. It is, I will tell you, it is with heavy heart because this project potentially did provide housing to the community. However, we have heard, days of testimony, and I too do not feel that they have met their burden of proof of satisfying the boundary amendment. For me, it is the constitutional obligation that we have under the Kapa'akai. I do not believe that there is sufficient evidence. I know for me personally, there is not sufficient evidence in the record for me as a commissioner to make that determination. So I do believe that the record is incomplete on that. And then I support all the other bases that Commissioner Okuda talked about, and I realize that there are many others, but my primary concern is the Kapa'akai analysis, and I do not believe in. I think their own witness admits to the inadequacies, so it's not just our conclusion. But thank you very much, Mr. Chair.
Thank you, Commissioner Chang. Commissioner Axon.
Thank you, Mr. Chair. Mr. Chair, I'm not a lawyer, and I cannot really dispute what Commissioner Okura's analysis are, but without exhausting the whole process that we normally do, and without hearing the rest of the parties their presentations, I'm really uncomfortable supporting this motion. Who knows? Probably if the whole process taking place, I might vote the same way as my fellow commissioners going to be voting. But again, I'm very uncomfortable supporting this motion without going through the normal process that we normally do, without hearing the rest of the parties. So I will be voting against the motion.
Thank you, Commissioner Axon. Commissioners, I'm noting that Mr. Yee has raised his hand, and because he had previously started to speak, I allowed the intervener to speak. Does the commission wish to allow for some statements, brief statements from the parties? If so, I'm going to call on, sorry, Commissioner Ohigashi.
I'm sorry, but I think that if we allow the interveners to speak, all parties should be allowed to make an argument in this case. I'm concerned about procedurally hearing to not permit the process. So I'm requesting that we should give an opportunity to all parties.
So thank you, Commissioner Ohigashi, and I'm willing to grant that motion, grant that request now. But let me be clear. I cut the intervener off when they were making a motion during the regular portion of the proceedings. Then a motion was made by the commissioners. Normally, parties are not called on once the commission has entered into deliberation. I do believe the petitioner has had many hearing days with a known standard to make their case, but I am more than willing to provide additional opportunity right now to hear from all of the parties. So I will hear from Mr. Ewan, then from the county, then from Mr. Yee for the Office of Planning, and we have already heard from the intervener. Mr. Ewan.
Mr. Chairman, I'd like the opportunity to respond in writing before the commission acts.
This would be highly unusual. Commissioner Okuda.
Thank you, Mr. Chair. Since I brought the motion in the interest of letting everyone put their arguments down in writing, I would have no problem personally anyway, even though I know it's up to the chair to manage this, to allow Mr. Yuen and all parties to submit something in writing. Although if the chair decides to do that, I think there should be a clear deadline made as far as when that would be submitted, and clarity on whether or not there will be a hearing where there's going to be oral argument, and what the schedule is. In other words, whether each party gets to file something in writing, and each party thereafter has a certain amount of days to file a reply.
I may need, as Commissioner Ohigashi.
I'd like to move for an executive session for the purposes of consulting our attorney, determining the process and duties and responsibilities of this commission.
Is there a second for that motion? I see no second. Okay, there's a second for the motion. So procedurally, if we go into executive session with our Attorney General right now, we will need to briefly reemerge from executive session to public session at 4:30 to end today's proceedings. We are out of time. So we would leave today's proceedings without any clear action to any of the parties. Before we move on to further discussion, would it be possible, I ask of our Attorney General, that the commission could the chair could issue an order giving a schedule and written responses if that's the chair's inclination?
Yes. And the presiding officer, you could do that.
Okay. We have two motions before us.
Chair, excuse me, I'm sorry. Who
Yes.
seconded the motion for executive
Commissioner
session?
Axon.
Thank you.
Mr. Yee, you're speaking about going into executive session. Briefly, please.
My comments will involve issues of procedure in which I would ask basically the LUC to correct certain matters that I think be corrected. I won't get into it because you have now it. If you go straight into executive session and then out and not hear from the parties, my concern is there is a procedural issue that I think could be fixed if you act today. Otherwise, it would have to be fixed later. I can get into the reasons if you would.
Yeah, I am solution-minded here.
I believe that the motion from the Land Use Commission is specific in explaining the specific bases. So I don't think it could be sufficient as to simply say you failed to comply with Kapa'akai. I think you would have to identify what part of Kapa'akai and what is missing from their facts. Similarly, I think there was indication there are a variety of reasons why you would be dismissing this matter. But in order to allow the parties, more particularly the petitioner, to reply, you need to specify the bases by which you're proposing to dismiss at this stage of the process. So I think you have some, but only some of the bases by which you would want to make a decision. Consequently, you're going to be restricted to those issues the next time you come back. Also, Mr. Collins, I'm guessing, would have other bases by which he would argue, specific bases by which he would argue and could lay it out. And that could be done by way of a written motion as well. I think you should be allowed to file that to also be answered by the parties. Okay. I'll stop there. Thank you.
Ms. Chow.
Yes.
Without violating any particular privileges, I could use a bit of procedural guidance here. We have two motions before us. I certainly want to, let me frame this. Yes, it is unusual that a commissioner would make, concluding only portion of the proceedings, a motion to dismiss. However, this has been a very unusual docket. And I believe there is certainly, by this, as evidenced by the second and the comments of Commissioner Chang, certainly at least some belief in the merit of such a move. How might you suggest that we, without unduly prejudicing any of the parties, move forward with this matter?
So, you know, if this, and it's difficult to do it in open session, but my standard advice would be that if this matter were to go up on appeal, a fuller record would be better than one that does not have as much information in it. And so I'm not saying that it should go through entire hearing, but if the LUC or the commission wants to make a decision on this motion, they should provide as much opportunity for the parties to address the particular basis of this motion and to have an opportunity to respond before the commission makes its decision, so that the basis for the commission's decision has been fully vetted.
Thank you, Ms. Chow. Commissioner Okuda.
Thank you, Mr. Chair. I did not make a motion just simply to save time. So that wasn't the intention. But since we're out of time anyway, I'm willing to withdraw my motion and we can come back for further days of hearing. That's not a problem. So, I mean, if we're now going to have questions about a full record, and I don't intend to just create more paperwork for everyone. Maybe it's more efficient since we're really out of time anyway. I withdraw my motion and we just proceed now with the other parties' cases since the petitioner has rested.
Ms. Chow.
Just to clarify, Commissioner Okuda, I was not suggesting that the commission should go through the entire hearing, but that the basis for the motion itself, the motion to dismiss, should be more fully set forth than, you know, in sort of eye towards the fact that we want to close the meeting at a certain time. So, you know, if Commissioner Okuda would want to more fully flesh out his reasons for the motion in sort of a written form, that might actually help the parties and the commissioners to review it and to respond to it.
Yeah, if I can respond, I'm happy to put things in writing. And in fact, as you can tell, I was trying not to just talk off the top of my head. However, if that's going to be the case, my suggestion is I withdraw my motion and let's just go forward with maybe 1 or 2 more days of hearings.
Commissioner Ohigashi, followed by Commissioner Chang.
Given the advice that Linda Chow has given that I hope to elicit in executive session, I withdraw my request for executive session at this time.
Okay, so Commissioner Chang.
Okay, yeah, thank you, Mr. Chair. My only recommendation is following Deputy Attorney General Linda Chow. I think the parties recognize what the motion is that's been made by Mr. Okuda, and I would accept Mr. Ewan's request to put it in writing, to give all the parties an opportunity to respond, and then I don't know when this is scheduled again, but I would like a full record. I want to make this, I don't want to do this again. Let me put it that way. Don't want to do these hearings again. So let's do it right the first time. I think Mr. Ewan has asked for an opportunity to respond in writing, and I would just urge that we provide him that opportunity as well as the other parties.
Okay, thank you, Commissioner Chang. Commissioner Giovanni.
I concur with Commissioner Chang, and I respect Mr. Ewan's request. I think it's a reasonable request. And I, for one, would like to hear and see in writing the positions of all the parties on this matter. I would encourage Mr. Okuda not to withdraw his motion. However, I think it might move these whole proceedings further if we could give this particular motion attention it deserves. And in the end, it might save time, it might not, but it will have a full hearing on the matter.
Okay, so the movants of the two motions have suggested they wish to remove their motions. I haven't sort of formally acknowledged that yet. We also have on the record that had the commission not made its motion, the intervener was planning to make a motion substantively regarding the same matters. Commissioner Okuda?
Thank you, Mr. Chair. Based on comments of Commissioner Giovanni, I withdraw my suggestion that I would withdraw my motion.
Okay. Y'all making this challenging. Let me summarize how I feel right now. Here's what I'd like to do. I'd like to first clarify with Commissioners Ohigashi and Axon that the motion to go into executive session is withdrawn. Ohigashi? The second is withdrawn? Yes. Okay. We now still have a motion before us made by Commissioner Okuda and seconded by Commissioner Giovanni. There's been a request from the petitioner to do written briefing on, I believe, particularly the issue of whether or not the petitioner has met the statutory requirements of their burden of proof under the law and rules in this case, as well as case law. And I am willing and think it would give us a full record in these proceedings to have written briefings on this followed by oral argument. Mr. Oradenker, do you have a suggested schedule for this matter?
Yes, Mr. Chair, I would suggest, given a heavy schedule coming up, that we allow the parties 2 weeks to file briefs and that we schedule oral argument on this matter and decision-making for June 10th.
So can you be more detailed in the order of briefs, and if you would suggest that there's any responses, written responsive briefs?
Well, briefs would be due by the 27th. And then rebuttals would be due, if the chair is so disposed to allow rebuttal briefs, they would be due on the 2nd of June.
And oral arguments scheduled for June 10th.
Yes, that's correct.
I believe as the chair, I can order this to occur, but I'm just going to ask the parties whether they have any concerns with this schedule. Mr. Ewan?
Will we get a written statement of the grounds for dismissal?
You will rely right now on the transcripts of today's hearing and the recording, which will be available within a couple hours after the close of this hearing, for the statements that have already been made by Commissioners Okuda, Giovanni, and Chang. Though if a motion is withdrawn and remade, there might be additional detailed reasons for the Commission's inclinations. Do you have further questions, Mr. Ewan?
No, I guess we would agree with the schedule.
Thank you. Mr. Donahoe?
Thank you, Chair. The county is agreeable to the schedule as well. Thank you.
Ms. Kato,
Sorry, Chair. if I-
Mr. Yee, who is also on Zoom, named Ms. Kato.
I'm so sorry. The schedule itself, we have no objection to. We do think interveners should be allowed to file a motion, in particular because we believe that the Land Use Commission will be restricted to the specific matters it identified, not the more general questions it has as to the adequacy of the proof. And I believe interveners may have an ability to present it with greater specificity.
So I also, if I'm correct, the intervener at any time can file a written motion on this matter.
Right, and I think that should be worked into the schedule so that we can all file, we all know when to file.
Which would be also pendant along with Commissioner Okuda's motion. When could the intervener file the motion that they orally discussed in written form? And could it comply with the proposed schedule that we've discussed?
Mr. Chair, yes, I was going to ask if we would be allowed to file basically a motion at the same time as the first briefs are due on the 27th, and then of course allow all parties to respond to that. I think that's more generous than what the default rules permit in terms of filing motions and responding.
Okay.
And I think most of our brief in support of Commissioner Okuda's motion is going to be duplicative of what's in our motion. There probably will be additional things, but
okay.
It's not like two separate things.
We have 5 minutes. Commissioner Ohigashi.
I just have one question. Mr. Collins, does that mean that you will be filing a combination memorandum as well as a motion at the same time, and that the rebuttal schedules will be set at the same time and no additional time is necessary?
Yes, Commissioner Ohigashi, we are suggesting that. It won't be a combination. We'll separate it so the record is clear, but it will be all at the same time.
I understand.
Okay, Mr. Donahoe.
Sorry, quickly, Chair. So for logistic purposes, for on June 10, 2021, should the county, dependent on the outcome of the motion, have its witnesses ready?
No.
No.
Okay.
No, if either Commissioner Okuda or the intervener's motion fails, the next step would be to then schedule further proceedings for the county to proceed with their case.
Okay. Thank you. Thank you, Chair.
I'm going to circle back to Commissioner Cabral.
Yes, thank you. I know you're in a hurry, but I got to get my 2 cents in. And I want to say, although I would think the writing's on the wall here, so to speak, but I would want to tell the petitioner how desperately clearly the island and the community appears to need housing, and to look at where the questions and the concerns are. So we can encourage people to proceed. Oops, yes.
I'm just going to focus this purely on procedure right now.
Okay, thank you.
Chair, if I may.
Mr. Oradenker.
I just want to point out that there is some concern about this, and I would point out that this motion we'll have to see how the scheduling goes. We have 2 SPs on the 9th and 10th that have to be heard because of legal time constraints on those days. So if we cannot finish those, this motion will have to be deferred.
The oral arguments on this motion.
Yes, that is correct.
Okay, but that does not necessarily change the briefing schedule at this point, correct?
No, it does not, but I just wanted to, no, it does not.
Thank you. So I'm going to circle back with Mr. Ewan, the petitioner. We've discussed a slightly different revised schedule that would also have the intervener file a motion along with their briefing on the commission's motion on the first date of deadline, and the scheduling going on as further. Do you have any problems with this procedure?
So essentially, if the intervener files a motion by May 27th, our opportunity to respond to the intervener's motion is June 2nd. Is that correct?
That is correct. Under this proposed schedule.
I guess if that's the schedule that you're gonna impose, that's the schedule we follow.
Okay. County.
Sorry, Chair, I'm okay with that.
OP.
Thank you.
No objection.
Commissioners. Having resolved the scheduling matters and set this matter for further proceedings, there being no other business on our schedule, I'm going to adjourn our meeting for today.